This is Brian Kaufman, Chairman of the Scottsdale Board of Adjustment, calling to order our regular meeting for November 3rd, 2021. If we could please begin with the roll call.
Chair Kaufman,
Present.
Vice Chair Metz,
Present.
Board Member Gonzalez,
Present.
Board Member Chacron,
Present.
Board Member Wagner,
Present.
Board Member Didi.
Present.
Thank you.
Thank you. Mr. Clough, do we have administrative items for today?
Yes, thank you, Chair Kaufman and board members. I do have a few items this evening. First off, if you noticed, we did have an update to the agenda. We added a continuance section to the agenda. Item 5 that was previously under the regular agenda has been moved to a continuances section. That was based on the applicant's request for a continuance to go to the January 5th Board of Adjustment meeting. Additionally, with regard to items 3 and 4 on the agenda, that's item 6BA 2021 and 8BA 2021. We did receive some additional correspondence, public comment regarding that case, both of those cases that were received after the 24-hour window to distribute those comments to you. So I'll let the record reflect that we did receive 4 additional comments regarding those cases. 3 of those were in support of the applicant's request, and 1 of those was in opposition. And then moving on, we did receive a request from a couple of the applicants this evening regarding the order of the other items on the agenda. So specifically regarding items 3 and 4, regarding the Scottsdale Recovery Center have requested to go last on the agenda after case 9BA 2021. So I'll leave that up to you, Chair Kaufman, and the board, whether you choose to adjust the order of the items on the agenda accordingly. Lastly, at this point, we don't have any items scheduled for our December 1st Board of Adjustment meeting. So unless something were to be continued from this evening, we'll likely be canceling that meeting. Thank you, Mr. Chair.
Thank you, Mr. Clough. And unless anyone's going to object, I think that's fine. We'll do, first we'll do the continuance of 7BA 2021, and then we'll handle 9BA 2021, and then we'll do the Scottsdale Recovery Center 6BA 2021, and then finally 8BA 2021. And then next on the agenda is the approval of the minutes from September 1, 2021. Does anyone have any modifications to the minutes? Otherwise, I'll move that we approve the minutes as distributed. Do I have a second, please?
I'll second that.
Thank you. And roll call, please.
Chair Kaufman,
Aye.
Vice Chair Metz,
Aye.
Board Member Gonzalez,
Aye.
Board Member Chacron,
Aye.
Board Member Wagner,
Aye.
Board Member Didi.
Aye.
Thank you.
Thank you. All right, next up, case 9BA 2021, the Brown residence. And I guess before we get started, I'd like to welcome everyone to the Board of Adjustment. The city encourages your interest and participation in the public hearing process. The Board of Adjustment is a 7-member board that has the power to hear and decide on applications for 1, variances from the provisions of the zoning ordinance, 2, appeals from a zoning administrator's interpretation of the zoning ordinance or other decision, 3, requests for disability accommodation made to section 1.920, and 4, general manager's interpretations and decisions made on appeals regarding the land division ordinance. Citizens wishing to speak on any agenda item may fill out a blue speaker card, which are these, and turn it in at the staff table before the agenda item is discussed. I will call on people by name when it is their turn to speak. When called, come to the podium, state your name and address, and then begin speaking. Groups wishing to speak should elect a spokesperson to represent the views of the group. To facilitate the meeting, your comment will be limited to 3 minutes for individual speakers. 1 additional minute for each additional individual present at the meeting who has contributed their time to a representative speaker, up to a maximum of 10 minutes per speaker. Please format your speech to be accommodated within the applicable time frame given. For convenience and timing presentations, a light system is installed on the podium. The light will be green for 2 minutes and yellow for 1 minute. Please conclude your comments when the red light appears. The first case we're hearing is a variance. It is a request for a variance of specific requirements of the zoning ordinance. The Board of Adjustment may only grant a variance when one of the 4 criteria established by state statute are met. These 4 criteria are: 1, that there are special circumstances or conditions applying to the land, building, or use which do not apply to other properties in the district; that the special circumstances were not created by the owner or applicant; that the authorizing of the variance is necessary for the preservation and enjoyment of substantial property rights; and that the authorizing of the application will not be materially detrimental to persons residing or working in the vicinity, to adjacent property, to the neighborhood, or to the public welfare in general. You must meet all 4 of these criteria in order for us to grant the variance. What that means is that when you get up to speak, either in favor or in opposition to the request, I ask that you please limit your comments to just those 4 criteria. Because of the constraints of state law, we cannot grant a variance just because it seems like the sensible or fair thing to do, unless the 4 criteria are also met. This board functions more like a panel of judges deciding whether the facts meet the test established by law than like a panel of elected city councilmen. In order to get a variance, you are required to get 4 votes, 4 or more positive votes in order for the board to grant your variance. Thank you for your interest and time. And then I apologize. It was 7BA 2021 that wanted the extension or the continuance.
Chair Kaufman, that's correct.
All right, I said the wrong first item. So let's go ahead and they wanted it to the December 3rd meeting, January 5th. I'll move that we continue item 7BA 2021 to the January 5th meeting.
This is Chairman Jason, Board Member Chacron, I'll second that motion.
Roll call, please.
Chair Kaufman,
Aye.
Vice Chair Metz,
Aye.
Board Member Gonzalez,
Aye.
Board Member Chacron,
Aye.
Board Member Wagner,
Aye.
Board Member Didi.
Aye.
Thank you.
All right, thank you. And then now we'll continue to the variance, which is 9BA 2021, the Brown residence. And we've got Waylon Barton from the city presenting first.
Good evening, board. Can you hear me okay? My name is Waylon. I'm a planner here with the city of Scottsdale, here to present case 9BA 2021, Sharon Drive addition variance.
It appears that the mouse and keyboard aren't working. Can we advance the slides verbally?
Thank you. Start the presentation. We have a context aerial of the sites. As you can see, this site here is nestled in the Desert Wind subdivision. To the north, we have the Patterson Ranch subdivision.
Waylon, real quick, do you mind moving the mic a little bit so it's kind of more directly in your face so we can hear you?
Sorry, can you hear me okay now?
Yeah, that helps a lot. Thanks.
Great. As I was saying, the site is in the Desert Wind subdivision. North is the Patterson Ranch subdivision across East Thunderbird Road. And to the northwest corner is a Scottsdale airport. Next slide, please. As we zoom in to the detail aerial, you can see our subject site here is intersected by 3 streets, East Thunderbird Road to the north, North 81st Street To the east and to the south is East Sharon Drive. Next slide, please. If we go to the existing zoning map, we see that the site is zoned R135, which is consistent with the site to the north, surrounding properties to the west, east, and south, also R135 zoning district. Next slide. To go over the history of this subject site, 1978 is when we start with the Desert Wind subdivision platted with Maricopa County. We have the main residence constructed in 1979, known as Lot 11 of the Desert Wind subdivision. And also of interest for this subject site is a previous Board of Adjustment case, 23 BA 1985, which granted two variances. The first was a 32-foot variance from the 40-foot front yard setback requirement along North 81st Street. And the second was a 3-foot variance from the required 10-foot distance between a main and accessory building. Next slide. For a bit of zoning context on these corner lots and their required yards, per Article 3, Section 3.100, a front yard of a residential corner lot is the yard adjacent to the shorter street frontage. In this case, our shorter street frontage is adjacent to North 81st Street, titled Legal Front, which puts the rear directly opposite. And as you can see with Lot 12, just to the west, we have a rear yard abutting a side, which is considered a key lot configuration. Next slide, please. So for today's case, we have separated out the request in two sections here. The first one is what we call variance request number one, and the next would be number 2. So to briefly go over the first request, it is a variance to the Scottsdale Zoning Ordinance, Section 5.204E3, pertaining to the required rear yard setback. In that provision, each lot shall have a rear yard setback with a minimum depth of 35 feet. This request today is a 20-foot reduction to that required 35-foot rear setback to bring the new setback at 15 feet for the scope of work of a main structure addition of plus or minus 2,176 square feet. And if we go to the next slide, I have a visual of what the first variance entails. In yellow there is the proposed 2,176 square foot addition to the west of the existing home. And the red lines indicate the current setbacks, including the setback on the east frontage that was previously granted under 23 BA 1985. As you can see detailed there, we have this new main residence extension encroaching in a required 35-foot rear setback. If you go to the next slide, you'll see the proposal is to adjust that 35 feet to 15 feet to accommodate this new proposed structure to the west of the main building. Next slide, please. And as mentioned earlier, we're splitting this up into two sections here for the variance request. The second request kind of goes into the previous amended front yard setback as granted under 23 BA 85. So under section 5.204E1 of the Scottsdale Zoning Ordinance, each lot shall have a front yard with a minimum depth of 40 feet. However, under case 23 BA 85, the board at the time approved a variance which reduced the required setback from 40 feet to 8 feet. The request we have today is an adjustment of 10 inches to that previously amended front yard setback, which would reduce the amended front yard setback on the parcel from the current 8 feet to 7 feet and 2 inches on that eastern frontage along North 81st Street. Scope of work would be to bring the existing overbuilt accessory structure into conformance, as well as the applicant is proposing to attach that accessory structure to the main structure. If you go to the next slide, some more visuals. Now we're focusing on the east side of the lot here in green. This is variance request number 2. This is an existing garage that there looks to be encroaching the amended 8-foot setback. I can see in the red lines. If we go to the next slide, you'll see it's just a minor adjustment to fully fit that green shape there, the existing garage, into the setback, as well as connect it with a proposed mudroom, as you see there on the plan. Next slide. So as we go into the criteria for a variance request, for the first criteria, we are including, as you see, variance 1 and number 2 together under this staff assessment. The first criterion, just for the record, states that there are no special circumstances applying to the property, which do not apply to other properties in district. Special circumstances must relate to size, shape, topography, location, or surroundings of the property. So under variance 1 and 2, staff's assessment, subject property here is approximately 36,037 square feet in size. The R135 calls for a minimum 35,000 square foot lots. This lot is similar in size, shape, and topography to the neighboring parcels. However, this lot here, as you saw on the aerials, is a triple frontage, which requires a front setback on 3 of the 4 sides. The existing home is orientated towards Sharon Drive. However, 81st Street is a legal front, as it is the shorter street frontage. And the last item here is the triple frontage condition necessitated relief along the eastern frontage under that previous case, 23BA 85. Next slide. For the second criterion, we have that split up between variance number 1 and number 2. So for the first variance here, this second criterion states that the variance is necessary for the preservation of privileges and rights enjoyed by other property of the same classification in the same zoning district. For variance number 1, the main building would be allowed to be located within 15 feet of the rear property line. It appears that additions to the main building could be constructed at other locations within the current required setbacks. Previously granted relief on the eastern frontage under that 23BA 85 case. As we assess the second variance request, staff acknowledges that the existing garage's location would remain the same, but would be attached to the main structure, which is consistent with the development pattern of the neighborhood. Next slide. As we move to the third criterion, states the special circumstances were not self-imposed or created by the owner or the applicant. As we break down the variance between number 1 and number 2, number 1, our assessment is that the subject property is approximately 36,037 square feet in size, similar in shape, size, and topography to the neighboring parcels. It was previously granted relief on the eastern frontage under 23BA 85. Also, triple frontage condition and orientation of the house were not created by the existing owner. And as we go to variance number 2, the home was originally constructed in conformance with the R135 development standards. However, the accessory structure was built 10 inches into the amended front yard setback on the eastern frontage. And next slide, please. The last criterion here, number 4, the authorization of the variance will not be material detrimental to persons residing or working in the vicinity, to adjacent property, to the neighborhood, or to the public welfare in general. As we split the 2 variances, our assessment of variance number 1, a structure would be placed 20 feet closer to the neighboring property line than as currently allowed under the R135 development standards. For variance number 2, we acknowledge that the detached garage has existed for almost 30 years in the same location. However, the combination of both requests, number 1 and number 2, would affect the overall massing of the main building, which may be visually obtrusive to the neighborhood. And that concludes staff's presentation.
Thank you. The house to the west, what's their setback requirement on that same wall?
The house to the west there would be lot 12.
8008, I think was the address.
You're talking about the lot across from North 81st Street or directly abutting our lot 11?
The lot to the west.
Yeah, that would be the R135 standards. Front would be 40, sides 15, and a rear of 35 feet.
So the lot to the west of the subject site for the same wall has a 15-foot requirement.
Yeah, so lot 12 that we're speaking about to the west of lot 11 has a 15-foot side setback. As we focus on lot 11 subject site, they have a 35-foot setback
For the
that is
same
joining
wall?
with that wall there in the middle.
And they're asking for 15?
Correct. They're asking for a reduction of 20 to make it a 15-foot setback.
So basically to match what their neighbor has on the same wall?
Correct.
Thank you. Other questions?
Yes, Chair Kaufman. As it stands now with the garage that was built 10 inches into the adjusted setback, is this property in general considered illegal and non-conforming?
The current structure, the existing garage, per the 23 BA 85 staff report and decision, the accessory structure was a proposed structure to adhere to an 8-foot setback. So the structure currently does not conform to the 8-foot setback and would be considered non-conforming.
And let's set aside for a second let's just assume for a second that we grant the variance on the west side of the property so that they can put this large addition on there. If we don't grant the variance to the garage and allow it to remain non-conforming and it remains detached from the home, are they permitted to build additional square footage onto the home as long as that garage remains detached?
I believe I can bounce this to Brian, but to address your question, the detached structure, I believe we would consider as an accessory structure, which would be different than the main structure, as a proposal is to attach a main addition to the main structure.
So the non-conforming accessory structure doesn't limit their ability to expand the main structure. Is that correct?
Correct, as long as they're not.
But as soon as they attach them, then the fact that it becomes all one structure says that they now have a portion of their entire structure that's non-conforming and therefore they couldn't expand it without the variance. Do I understand correctly?
Correct. It'd no longer be considered an accessory structure when you attach it. It would be considered all one main structure.
Thank you.
Real quick, just to summarize, if we only gave the western variance and we denied the eastern variance, would they still be able to do the expansion that they wanted on the west side? There's no like certain percentage expansion that they're exceeding or anything like that?
Yeah, we have legal non-conforming provisions in our zoning ordinance pertaining to a non-conforming structure and the allowances for that main structure. We would be separating out the review between what the work would be to the accessory structure that's non-conforming versus the structure that is currently conforming to the setbacks of the zone.
Go ahead.
When you were describing these special circumstances, you mentioned that there's triple frontage here. And so my question is, if they've already been given relief on the legal front, which is the North 81st Street side of the house, so that it's an 8-foot setback there, is it still appropriate to say that there's triple frontage there? And I'm just trying to figure out how they stand relative to the other parcels in the neighborhood in terms of what their frontage requirements are, and are they really special and different?
Yeah, if we reflect back to 23 BA 85, the meeting minutes, I believe, are an exhibit in your report. Through the meeting minutes, it was just an adjustment to a front yard setback. So there was no reconfiguration of what we would consider a side or a rear. It was just a dimensional reduction of a 40-foot front to an 8-foot front, but still considered a front yard.
And the other thing real quick about that is I think they're potentially still special because they still have two opposing front yards where they still have that 35-foot setback on two opposing sides, which I think is definitely a unique impact to them.
Yeah, well, that's what I'm trying to get to.
Yeah, as it stands, they have 3 fronts.
They have 3 fronts, but one of the fronts has the setback has been reduced to 8 feet. So
Correct.
So presumably that means that the burden of having that frontage has been eliminated. Is that fair to say?
Yes, instead of 3 40-foot setbacks, we have 2 40-foot front setbacks and the amended 8-foot front yard setback.
Right. And so my question is, how special is that relative to the other properties in the neighborhood?
If we look just across the street from North 81st Street, we see a similar type of construction on that lot. And you're meeting in the report, there's meeting minutes for that lot. I believe it's lot 10 for that variance that was granted for that lot there, which I believe was a 28-foot reduction to the front yard on North 81st Street. So those are your triple frontage lots, examples that are right side by side from each other. They both have had relief from North 81st Street.
Chair Kaufman and board members, if I may add to that, although the eastern frontage along 81st Street did receive relief for the dimension of that front setback, it is still the shortest frontage of the lot, making it the legal front, which is the determining factor of which side is the rear. So that's requiring the 35-foot setback along the west property line.
Thank you.
Any other questions? All right, thank you.
Right, and the applicant, Peter, is here for his presentation.
Mr. Valenzuela, go ahead. Thank you.
Good evening, Board of Adjustment. For the record, my name is Peter Valenzuela from the Genesis Group Government Relations, 7272 East Indian School Road, 85251. I'm here tonight on behalf of item 9-BA-2021. That's the unit at 8014 East Sharon Drive for an addition and remodel. Okay, we have on the first slide here, we have, it's showing us property photos. Image 1 shows the driveway facing south. Image 2, all surrounding driveways that face Sharon Drive as well as ours. Images 3 and 4, the site has a full height masonry wall facing 81st Street with the exception of a gate. And image 5, it shows you that Thunderbird is a very large, busy road, and 81st provides an access point to the neighborhood. Next slide, please. Okay, this slide kind of discusses the big picture. Well, I know that that staff has already covered it, but again, the site was annexed in 1962. The current zoning designation is R135. The house was constructed in 1979, and the neighborhood is bordered by major streets, and 81st is the main access point to the neighborhood right next to the site. Next slide, please. Okay, I want to go ahead and discuss a little bit the function of 81st and the non-vehicular access easement. The original designers of the Desert Wind community placed a 1-foot non-vehicular access easement along Thunderbird and 81st Street to ensure that no driveways would be created that would cause unsafe traffic conditions. This means that functionally, the front yard of our property must be on the south side. Currently, this creates the most restrictive scenario possible because the site as is must have 3 40-foot street setbacks as well as a 35-foot backyard setback on the west side. Next slide, please. Sharon is the main road and right across, okay, the site on the other side of 81st Street had the same condition on their 81st Street property, with the line being considered the front yard. And this is the home right across the street from us, which is address 8020. Next slide, please. Okay, restrictive setbacks. I want to point out that the restrictive setbacks is the most restrictive scenario possible. We have streets on 3 sides of our parcel, and we have a backyard setback on the 4th side. If Sharon was to be considered the front yard as it should be, then the west side would only have a 15-foot setback and would provide the site development opportunities that are equal to the surrounding properties. Next slide, please. Okay, I want to go ahead and discuss quickly our site, the variance requests. If you look at the blue line, it shows that the blue line shows existing house and setbacks. Let me see, I'm on the wrong slide here. Okay, I'm sorry. Okay, point out the restrictive setbacks on this slide, same slide. Most restrictive scenario possible, streets on 3 sides, backyard setback on 4th side. If sharing was considered, it would be the 15-foot setback and provide the site the development opportunities equal to surrounding properties. Next slide, please. Okay, on this slide here, you'll show that the blue shows the existing house and its setbacks. The green shows the existing garage and the approved variance. However, the existing garage was built with a 10-inch over its variance. So we would like to clean that up too at this hearing if possible. The red is the proposed addition and garage attachment. Red setback lines equal the proposed variances to the setbacks. Next slide, please. This goes to the criteria. Criteria 1. Is this a special circumstance? Yes, this is a special circumstance. Out of the 75 properties in this development, only 4 have the same condition of being bordered by 3 streets. And 2 of the 4 properties were granted the ability to develop their site to the same capacity as the more standard sites in the development. We would like to follow their lead and request the same. Up above, you have the larger 2 images up on top of this slide. Okay. It shows that the images of the top of the slide show the buildings go pretty much to the property line from east to west. Next slide, please. Criteria number 2, will this grant special privileges? If this variance is approved, it will not create a special circumstance or favor this property. It will give the property the same opportunity to expand and develop as the other typical properties within the development. Criteria 3, are the circumstances self-imposed? This circumstance is not self-imposed. It comes from the Scottsdale zoning code being applied to a site in a way that is not logical or fair for this particular parcel. The front yard being on the east really doesn't make a lot of sense. Thus, it creates an unfair burden on the site with the most restrictive setbacks combination that's possible as per code. Next slide. Criteria 4, will this approval disadvantage other sites? No, it will not. The variance we're requesting will allow this site to have the typical setback scenario. No buildings will be closer built than normally allowed to the neighboring property as per the Scottsdale zoning code. Next slide. And here are the proposed renderings we have. They all look very nice here. If you look at them, it's going to go ahead and enhance the neighborhood. The proposed addition and exterior renovation will bring value to the house itself, and there'll be added value, and it will improve the value of the neighborhood and bring an additional aesthetic to the neighborhood as well. That's my presentation.
Thank you, Mr. Valenzuela. Any questions from the board? Mr. Valenzuela, do you know anything about the circumstances of that garage being built 10 inches over the amended setback?
You know, I've got the contractor and the applicant is here with me, and his name is, he's got a card to speak as well. Could you want to address some of this?
But if you don't mind, you want to hit the mic? And make sure you state your name and let us know who you are.
My name is Sage Lentz with Sage Luxury Homes. On this, to answer your question on the structure, it was built roughly, let's see, I think about 20 years. 1985 is when that structure was built. It's an existing structure. I don't have a reason why it encroaches by 10 inches, other than probably a surveying error that may have occurred when the structure was built. That's the only knowledge I have, just because of the age of the structure that's there.
Is it permitted?
It was permitted, yes.
So presumably the city came out and inspected and gave it the stamp of approval?
Correct.
All right, any other questions for either of these guys? I think Mr. Valenzuela left a couple minutes. Sage, did you want to make a few more points?
Yeah, probably the couple points I would make on this is we're not asking for anything that's above and beyond what's been done on the street there. The property to the east of 81st Street that has the same characteristics as what we have, and that's the 8020 East Sharon property. We're really matching what they did there. So I think unfortunately back in 1962, 63, when this was platted, that 1 foot non-vehicular setback, I think it got missed with staff, because had they followed that 1 foot non-vehicular statute, the front yard would have been recognized back then as Sharon. So somehow I think it just slipped through, because all of those homes along Sharon, including 8020, they all face Sharon Drive. So I think it's just one of those things, honestly, that just slipped through the crack, and here it reared its head when we were working on the plans here. So I think it's one of those cases that you just look at and go, gosh, that's just strange. How in the heck did that happen with the setbacks and how it's positioned on the lot? Because obviously when you see the house, how it's built, it faces Sharon, so, and that's when it was built, back in 1963. So anyway, those are the comments. That we're not doing anything unusual for the street, and I really appreciate all of your time this evening for our consideration. Thank you.
All right. I guess quick
I
question.
have one more for you, if you wouldn't mind.
Yes.
Have you had any conversation with the homeowner to the west?
To the west, I have not, no.
Okay, and we were told by staff that there is a 15-foot setback because that's a side yard. Do we know if their house is built at 15 feet from that common wall?
It's fairly close. I can't tell you if it's exactly 15, but per the photo, the arrow that we have, it's fairly close. And I don't know when their structure was built, if they added on to it. But there we go, right there. Oh, yeah, there. Now you can see the property to the west. There it is. So to your question, I'm not exactly sure of the exact footage that they are off the wall, but we're just matching the neighborhoods is all we're doing.
Okay, thank you.
Okay, thank you.
All right, thanks, everyone.
Constructed in 1979, not 63.
Say that again into the mic, please.
And okay, it was the community was developed and annexed in 1962. The house was constructed in 1979.
All right, thank you. Okay, anyone want to speak their piece first? Otherwise, I'm going to start calling. Mr. Gonzalez down there, you have any comments?
Thank you, Chairman. When I look at this project, basically it's dealing with two things. One, a variance for the 10 inches for the garage that was built 20-something years ago in the wrong place. I don't have a problem giving a variance on those 10 inches. On the west side where they're planning the new addition, according to the schematic that they gave us, that addition is 2,175 square feet. Just looking at it, the home is 3,575. And when I look at how far that intrudes into the setback, I'm thinking that the planned addition exceeds the amount of room that's really available for this addition by considerable. Now, we talked about the neighbor being close to the fence. I don't know who the neighbor is. I don't know whether their structure was permitted, unpermitted, a variance, or what. So, but the zoning in that area is a 35-foot setback from the wall. And while I realize that there's 3 streets that affect the frontage, that back fence isn't affected by the streets. And so I'm not sure that the size of that addition and the intrusion into the setbacks that the city has allowed in that zoning variance, I'm not sure that I can agree that there's a real variance there based on the fact that I'm not sure that the addition is really suitable for the location of the house on that lot, and I'm not in favor of the addition. I think it's just too big for the lot. Thank you.
Thank you, Board Member Gonzalez. So just to maybe elaborate a little bit on the rear yard to the west being a 35-foot setback. The reason for that is because of the way that the lot is oriented. The east is the front, which makes the west the rear. And that gives them the 35-foot setback, even though for all intents and purposes for the entire neighborhood and including this lot, the front yard is to the south. And so that should basically be the side wall. And it should only be a 15-foot requirement if the lot lined up with the house and with the rest of the neighborhood. His neighbor directly to the west for the same wall, he's got a 15-foot requirement. As far as I'm concerned, I think this is a classic special circumstance because of the 3 frontages. I think he is losing a right that other people get because just for that weird, and it's just because the Witch Street happens to be longer as well. So he's losing out on that 15-foot setback that his neighbor has just because of that slight coincidence of the length of the streets and the fact that there's 3 of them. That is, I think clearly all 4 criteria are met. He should have a 15-foot setback, just like his neighbor, just like the rest of the neighborhood on that west side. So I'm for the western setback. On the east, I'm gonna maybe withhold judgment for the time being. I think we see a lot of these cases where something was permitted and built, A-OK, stamped by the city, and then it ends up being over by 10 inches a foot, whatever it is. And I think usually we've given them, I'm, to be honest, a little bit not that crazy about it. I don't think there's really a special circumstance. I don't think, yeah, I'm not sure. I'm going to wait and see if anyone can convince me on the east side, but on the west side, I think it's clearly met all 4. And with that, Board Member Didi, you want to elaborate on your comments?
The criterion that I'm most focused on is the one that says that the variance is necessary for the preservation of privileges and rights enjoyed by other property of the same classification in the same zoning district. And I think it comes down to kind of how do you define privileges and rights enjoyed by other property? Does that mean that you get to do exactly what they do and that you can build a house that's exactly as big as your neighbors do? Or does that mean something, is there a higher standard there? Does that mean if I can't have a garage on my property and people have garage, everyone has a garage in my neighborhood, so I need some relief to have a garage? When I look at the house, it's a good size house. There is a garage, there is a pool. The addition is large. There's no doubt, I drove through the neighborhood. There's no doubt that the houses being built there right now are big and they're really wide. They go from side to side. And I understand that what you're doing is probably consistent with the other building that's taking place in the neighborhood. I guess I'm not totally persuaded that that second criterion is satisfied, because I'm not sure that that means that you get to do exactly what everyone else is doing. And so I guess at the moment, I'm not going to express an opinion one way or another, but I'm on the fence there. I understand that that should be the side yard, and logically you would have it as 15 feet because those are the 2 sides, but that's not what we're dealing with here. And as far as the 10 inches goes, I'm also kind of, I would want to understand a little bit more what the significance of granting that variance is relative to simply allowing this to continue as a non-conforming use. Since the original setback reduction was given to 8 feet, and for some reason, which we don't fully know, it went beyond 8 feet. So I guess I'm not going to make a decision on either right at this second.
Thank you, Board Member Didi. And as far as point 2, to my mind, the right, the privilege or right enjoyed by other parties is to be able to build within 15 feet of their side wall. And in this case, this guy, he's got no side yard. He's got 4 huge setbacks, 40, 40, 40, 35. And even though one was helped, I think he's still pretty hampered compared to his neighbors by that 35 foot on the other side. And I think everyone else in his neighborhood has the right and privilege to have their 15 feet from their side yard. And I think he deserves to be made whole. Were you wanting to go ahead, Vice Chair Metz?
Thank you, Chair Kaufman. We've dealt with lots of properties like this. It's a little bit odd that the city definition says the front yard is technically the one with the shorter side. And you sometimes run into funky circumstances like this one. I'm not convinced by the argument that this house should have a 15-foot effective side yard setback because his neighbor does, because the other side yard setback has already been reduced to 8 feet. I asked staff to give me some information on the buildable square feet of various lots. The other item here is that, is this property unique? Are there special circumstances? It has 3 frontages, and that makes it kind of unique, but not 100% unique. There are lots of other properties, not a lot, but several other properties, even in this division, that have it. And across the street, across Thunderbird, there are more. And I asked staff to give me some for multiple lots that have 3 street frontages or even 2 street frontages, what the size of the lot is and how much the current buildable portion of that lot is. And as the setbacks sit today on this property, the owner can build on 45% of the square feet of the lot. There's a double frontage within this division that can only build on 44%. There is a triple lot frontage, lot number 17, that can only build on 43%. Across the street at Patterson Ranch, there's one that has 43% and another triple frontage that has 43% that they can build on. So I'm afraid that this issue of granting special privileges is a concern to me about the side yard, about the west being reduced. I'm not concerned at all about criterion number 4. I don't think this would be detrimental to the neighborhood. I visited this property as I do all of our sites and drove through the neighborhood, and they're big houses and they typically are 15 feet from the neighboring property. Regarding the eastern frontage and the 8-inch, a 10-inch encroachment into the granted a reduced variance, it's not really self-imposed, right? Because someone else did it. I assume that happened before the current owner. But when we continue to grant these variances for buildings that are built out of spec and against the variance that was granted, we're in essence creating a perverse incentive for people to violate the variances that are granted to them and then sell the house and let the next person come back and beg for forgiveness. 10 inches isn't a lot. Also, I'm struck by the fact that even if we grant the western variance to allow this large addition, if we did that and they didn't attach the garage to the main structure, then they could go ahead and do that. So the need to build into that section, should we grant the western variance, would be self-imposed by the act of attaching the garage to the structure. So at this point, I'm not really sure that I'm pretty sure at this point that I can't vote in favor of either variance, primarily because of criterion number 2, it being ending up granting a special privilege. Thank you, Chair.
Thank you, Vice Chair Metz. Board Member Wagner, any comments to add?
Yeah, I actually consider that they meet all 4 of the criteria. I believe that there is a special circumstance on this lot primarily due to the non-vehicular easement. So many of the other ones do not have that other than the ones off 81st. So it does create a unique situation. While it's a legal frontage, there should be really in conformance to the other lots in that subdivision, 2 sides and a front and a back. So to provide a side yard at 15 foot, that is very similar to all the neighbors, would be reasonable. Again, I don't think that it's self-imposed nor material to the detriment of the community either. So I tend to agree that the 10 inches is concerning, but it is not something that was self-imposed. And I understand that creating the situation that because it's being attached, it's no longer considered an accessory dwelling like it is right now, creates a situation that it's non-conforming. But I could see it meeting all 4 of these criteria for both requests, the number 1 and number 2.
Thank you, Board Member Wagner. Board Member Chacron, anything to add?
Yes, sir. Thank you. So I live in this neighborhood. I'm only a couple blocks from this property. And when we look at how it annexed in 63 and what we're doing today in 2021, this property shouldn't have been positioned the way it was, in my opinion. And bringing it up to what I consider today's code with a 15-foot side setback and a 15-foot side setback, I'd argue the point that in 85, when we gave the variance for 8 feet, that shouldn't have been done. Because I would have looked at it as looking at the house, how it's oriented today, the front's in the correct spot because the city said don't enter in off of 81st. So we entered on Sharon. So the left, or what they consider the rear, should be a 15-foot setback, and where that garage is should be a 15-foot setback. That's what I personally believe. I believe all 4 criteria are met with this property, no matter if they're going to build all the way up to the 15-foot setback or 20 feet from a setback or whatever. I believe that the property is the property, no matter how much you're going to build on it. The 10-inch setback is not something that they created. That's something that the city created. We provided a variance, we provided a permit, we didn't measure it properly, and we stamped it. If you look back at the history of this board, we've provided variances for the mistakes of the city. We've done it a number of times. But we also don't provide variances for people that build something without permit. This situation right here, in my opinion, is we're bailing out the city and giving them that 10 inches because the city provided a permit and measured it incorrectly and stamped it. I feel like we have to do that for this property. Unfortunately, in 85, if I was on the board, I wouldn't have allowed for an 8-foot setback. I would have kept it at 15. So for me, I like the 15-foot left. I like the 15-foot right, 40-foot front, 35 back. That's what I have in my house. That's what I believe all these properties should have. And if this was oriented properly in 63, we wouldn't even be here. But we are. I agree that all 4 criteria are met, and I would approve both requests for this. Thank you.
Thank you, Board Member Chacron. Anyone want to add any more comments or respond to any of the other comments? No other input from the board? Sounds like we're going to have a close one. Why don't I start by, I'm going to go ahead and make a motion for one of the setbacks first. And this would be a motion to approve the setback, the first setback, 20 feet, which would reduce the required rear yard west setback on the parcel from 35 to 15 feet. Do we have a second?
I second that motion.
Thank you, Board Member Chacron. Any other comments on the first? Otherwise, let's go ahead and have the roll call vote.
Chair Kaufman,
Aye.
Vice Chair Metz,
Nay.
Board Member Gonzalez,
Nay.
Board Member Chacron,
Yes.
Board Member Wagner,
Aye.
and Board Member Didi.
Nay.
Thank you.
All right, so that would be a 3-3 tie if I'm not mistaken. All right. Do we want a motion to not approve, or do we just want to continue it to a future meeting? Anyone have a preference?
Oh, I'll give it a try. Chair Kaufman, I'll move that we deny variance number 1, which is the west setback reduction from 35 feet to 15 feet.
I second that motion.
Roll call vote, please.
Chair Kaufman,
Aye.
Vice Chair Metz,
Yes to deny.
Board Member Gonzalez,
Yes to deny.
Board Member Chacron,
No to deny.
Board Member Wagner,
No to deny.
and Board Member Didi.
Yes to deny.
Thank you.
All right, and that passed 4-2. All right, thank you. And then second would be for the eastern setback. Is someone in favor of that want to make a motion?
I'll make a motion to approve the second request.
I'll second that motion.
All right, see no other comments. Can we have the roll call, please?
Chair Kaufman,
No.
Vice Chair Metz,
Would you come back to me, please?
Board Member Gonzalez,
Could you repeat the motion, please?
To approve the second variance, which is for the eastern frontage, the 10 inches.
Okay, I'll vote yes on approving that.
Board Member Chacron,
Yes.
Board Member Wagner,
Aye.
Board Member Didi,
Aye.
and Vice Chair Metz.
Aye.
Thank you.
All right, so it sounds like we approved the 10 inches on the east side and we denied the 20 feet on the west side, and it's all final decisions. All right, appreciate it, everyone. And I guess now we'll move on. Now to the main event. We've got the Scottsdale Recovery Center. And first is 6BA 2021, the appeal of the zoning administrator interpretation.
Chair Kaufman, if I may ask, would the board prefer one combined presentation from staff covering both cases, or would you like to hear them independently?
Let's stick with just the zoning administrator appeal first.
Okay, thank you.
And this is Jeff Barnes, right?
It is. My apologies. Hopefully you can hear me better.
Yep.
Chair Kaufman, members of the board, I am Jeff Barnes with the city's planning department and covering first for you the appeal of the zoning administrator's decision, which is case 6BA 2021. Next slide, please. This first slide shows some large context for the area. This site is located to the west of Hayden Road, south of Thomas, north of Oak. Next slide, please. Getting a little closer view, you can see it's on the north side of Wilshire. Again, just in west of Hayden Road there. It's an existing developed site. Contains 2 buildings with a courtyard space in between, parking around the outside. There are a total of 10 condominium units that make up those 2 buildings. Next slide, please. This site carries medium density residential R3 zoning, which is a multiple family zoning district. It's surrounded by other multiple family zone properties in that immediate vicinity. Next slide, please. I mentioned the building configuration and the context. We can move on to the next slide. So when talking about appeals to the decision of the zoning administrator, the board is tasked with 3 components to those requests. The first component is a determination of jurisdiction that the board has the authority to hear and decide on the request. The second is that of standing to determine that the applicant has standing to have made the appeal. And then Thirdly, action can be taken once both jurisdiction and standing are agreed upon, and the board may then hear the details and discuss and determine whether or not the zoning administrator's decision was arbitrary, capricious, or an abuse of discretion as laid out in the zoning ordinance. Next slide, please. So the interpretation request that we're talking about was given on June 23rd, 2021, which determined that the proposed use of the property does constitute a care home by designation in the zoning ordinance. And being that care homes are not a permitted land use in the medium density residential R3 district, would not be allowed at the property, which has addresses 7910, 7920 East Wilshire. Next slide, please. Given a just quick run through of applicable history related to this application, as with most of our application processes, this started with a pre-application submittal back in April. With that submittal, staff had initially identified that based on the request to do a sober living facility at this location, that it would fall under the designation care home, and care home, as I mentioned, is not an allowable use within that zoning district. Staff reached out to the applicant, let them know, and they opted to still proceed forward with the pre-application meeting. And so that meeting was held, information distributed similarly to that. In May 2013, the applicant submitted a formal request for interpretation of the zoning administrator about the use of the property, seeking determination that the use was not a care home and instead another allowable land use within the R3 district. In the time while that interpretation was being processed, the applicant proceeded forward with purchasing the property. And on June 23rd, 2021, the zoning administrator issued his written decision that did confirm that the land use is a care home and would not be permissible at that location. The appeal was filed July 1st, which is this case that you're hearing today, 6BA 2021. Of note, there was also a disability accommodation request, a reasonable accommodation request that was filed under 8BA 2021, which is the other item on your agenda tonight. Next slide, please. So as I mentioned, the requested interpretation, just covering some of the details of that, was seeking that the zoning administrator find that the proposed use was not a care home, but instead analogous to dwelling unit, which is something that's permissible within that district, similar to being occupied by a family as defined in the zoning ordinance, or potentially analogous to a group home, which is another permissible use in the district that is not, or different, I should say, from a care home. Next slide, please. So I mentioned, so I'll skip through this quickly. The zoning administrator's determination again was that it was indeed a care home. The city does not separately have a sober living use designation, and that was the outcome of that decision being appealed. Next slide, please. So getting into some of the details of what was considered by the zoning administrator with that decision, there was city council action in 2017 that adopted ordinance 4326 and resolution 10963. That was a text amendment to the care home language within the zoning ordinance that basically accounted for the adaptation of care homes over time, and that they included more than than just residential elder care and similar uses, and incorporated a variety of disability-related care that includes suffering from substance abuse and the recovery process for that. It was opted with that action not to separately identify sober living as a land use and continue to include it under the care home general umbrella designation within the zoning regulations. Also of note within those details is that care homes are specifically allowed within single-family residential zoning districts. The other component outlined on this slide that's taken into consideration when differentiating care homes from just dwelling units or group homes is that there's a licensing component involved through the Arizona Department of Health Services. And so the applicant in their application materials has identified seeking a sober living license, which is a type of license the AZDHS issues. And it's a component of the city's distinguishing factor that of a care home versus just a regular dwelling situation. Next slide, please. So covering a few definitions. So the zoning ordinance offers a definition of care home that talks about not more than 10 individuals with a disability living together as their primary residence in a licensed healthcare institution, and that there's supervisory care and other care services that occur within that location. Also identifying that persons live there for a minimum of 30 consecutive days to be considered their primary residence, and that care home is a principal land use, not an accessory land use. The state includes a definition for sober living that similarly talks about premises for alcohol and drug-free housing that includes supervised setting for a group of unrelated individuals who are recovering from substance disorders, and does not it's not offering medical or clinical services on site, but is there for that licensed purpose. The next slide, please. We'll get into one more definition, which is the state's definition of healthcare institution, which goes on to talk about a little bit greater detail of service for similar living conditions where medical services are provided, nursing services, behavioral health, and other similar types of care being offered in supervisory care. The key to talking about each of those definitions is that the sober living definition, the healthcare institution definition, all of those things revolve around supervised activities, promoting care, and those align with the city's definition of care home, which is part of the rationale viewed by the zoning administrator in making that decision. Next slide, please. Part of the initial interpretation request was seeking whether or not this was a group home. And so this slide is touching on the definition of group home, which is a dwelling shared by more than 6 adults as their primary residence with no supervisory or other care being provided. And so part of the determination was that this would not be a group home based on the applicant's identified operational parameters with 2 to 4 persons in each condominium unit, and that they are seeking a license, and the licensing element involves some component of supervisory care for the sober living use there. And so that would not be, based on the zoning administrator's decision, able to be considered a group home. Next slide, please. So the appeal filed is basically identifying that the zoning administrator had made his determination erroneously, and that this should be viewed as still a dwelling situation to be analogous to just families residing in these units. The applicant would like the board with that appeal request to find that that's the case and allow this land use under that dwelling unit designation or something similar in order to allow it in the R3 district. Next slide, please. So circling back and summarizing the findings that were contained within the zoning administrator's determination, the city council actions back in 2017 with the updates to the care home text had specifically laid out a path where sober living facilities were included in the city's care home designations. And so the applicability of this as a care home is following exactly what was adopted by city council. And that should the interpretation be viewed otherwise, that would allow for things that weren't contemplated as part of that action to go in any sort of zoning district that would allow for dwelling units as opposed to care homes. It should be noted that there are allowances within multiple family residential districts that are typically viewed as residential healthcare facilities that cover more intensive care settings within those more intensive zoning districts. Next slide, please. And that would be the end of staff's presentation regarding the appeal. The applicant is also here and ready to provide information relative to their request.
Thank you, Mr. Barnes. Is the only issue here whether or not this proposed use is defined as a care home?
Chair Kaufman, the core issue is it being defined as a care home, which would make it not an allowable use in the district. And at the core of that is the licensing component and the operational component falling within the city's designation for care homes.
And then there seemed to be a lot of information about other types of places like group homes, blah, 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 blah. Is any of that relevant? Or, I mean, it seems like the only thing that matters is it a care home or not? It's not our job to define what it is necessarily. We can just say it's not a care home, and then it's up to the city to decide what to do, how to handle the situation.
Chair, if I may, and it may be, I may be stepping on the toes of our legal staff. I believe your task in this is identifying whether or not the zoning administrator made his decision appropriately and was not acting out of turn with his decision.
Okay. The requirement for the care home is, I don't know if we can get it back up on the definition back up on the screen, but it seems like, as you identified, it hinges on being licensed as a healthcare institution under Arizona law. Is there such a thing as a healthcare institution license? Is there a specific license under Arizona law for healthcare institutions?
Chair Kaufman, it's my understanding there are several licenses for different varieties of healthcare institutions, one of which is sober living homes, another is residential healthcare facilities, assisted living facilities. There are multiple levels to that.
Okay, maybe we'll get more clarification later because I don't understand that to be the case. Any other questions from the board?
Chair Kaufman, maybe this is a procedural question. Mr. Barnes just presented a summary of Mr. Grant's, the zoning administrator's interpretation. And I have some questions about that? Should I be asking that now and ask Mr. Grant to come up, or is there another part of the presentation where it would be more appropriate for me to ask questions of Mr. Grant?
Mr. Clough or someone on admin, what do we normally do? Are we going to have a third speaking section for the zoning administrator?
Chair Kaufman and board members, there would not be a separate designated period for him to come up. So if you have questions for the zoning administrator, now would be an appropriate time.
Then I would like to ask a couple of questions of Mr. Grant. Good evening, Mr. Grant.
Good evening.
I'm glad that Mr. Barnes left this particular page up because up here is a definition per our zoning ordinance, that is the one that we are relying on, in which I believe it's your task to interpret, of what a care home is. And included in this is the phrase in which on-site supervisory or other care services are provided to the disabled residents. If the applicant said there is no on-site supervisory provided to the disabled residents, would that then lead you to conclude that the site in question is not a care home because it doesn't meet that portion of the definition?
Mr. Chairman, members of the board, I'd like to think about that for a moment and maybe talk to Mr. Clough.
Sure. Thank you.
Thank you, members of the board. Because there is a statutory requirement for the state to issue a license for this, and the license defines a care home facility for which this institution would qualify. I believe that's the reason that this would continue to be a care home under our ordinance.
To be clear, our city ordinance was careful to define care home shall mean and put specific words in. And I think what you're saying is that even if a particular facility didn't meet the requirements of this definition of a care home, it could still be, and you interpret it as a care home.
Correct, because of the state licensing requirement.
Thank you.
Any other questions from the board, either from Mr. Barnes or the zoning administrator? All right, appreciate your time. And I believe we have Ms. Dukes for the appellant.
Thank you, Chairman Kaufman and members of the board. Before I start, I have a quick procedural question for you, Chairman. We have Daniel Lauber on Zoom. He is our expert witness. And because we're taking these cases separately, there are some items that I would like him to address from his expertise in helping jurisdictions develop these ordinances that apply to the FHA laws and persons with disabilities. So if I give my presentation in approximately, let's say, 15 minutes, could we also assign him 15 minutes to provide his testimony as well?
I think my understanding of the rules is you get 10 minutes for each presentation. So you would get 10 minutes now and 10 minutes at the next.
I apologize. I looked through the rules of procedure in the zoning ordinance and I did not find a time limitation.
Mr. Clough.
Chair Kaufman and members of the board, 10 minutes is the typical time frame given. However, at the discretion of the chair, additional time can be granted.
This other guy on Zoom wants 15 minutes for himself.
Correct. And I can limit my presentation as much as possible. I know that the board has an interest in having all of the applicant's parties present. We're not trying to add any to the public comment section, but I do also think it would be important for Michelle Sywick, who's the owner and operator of this facility, to give you an overview of what operations are being conducted at this sober living home, because it goes directly to the definition of care home and whether there's any type of care services or supervisory care services being provided on site. So I think 30 minutes total would be sufficient time to address those issues.
All right. And your proposal would be 30 minutes total starting right now, or?
Correct.
All right, we'll do that. And when we get to the next section for the accommodation, then we just won't have you speak at all. You'll do everything right now.
So Chairman, part of the reason we had requested to consolidate the two cases was because there's underlying facts that are very similar, but when it comes to the actual interpretation and case law, there are 8 tests for a reasonable accommodation. And we have co-counsel here, Sarah Hunt, who is going to give that part of the presentation to address those criteria for a reasonable accommodation.
Okay, I mean, so go ahead and present everything like you planned, 30 minutes starting now. But up here, we're going to split it between the 2 requests. First, we're going to handle the appeal of zoning administrator, and then we're going to discuss the reasonable accommodation request.
Okay, thank you so much. I appreciate that. Okay, so I'm going to skip introductions for the time being, and I do want to go to slide 2 of the presentation. And so the first case that we're presenting before you is an appeal of the zoning administrator's interpretation. And again, the zoning administrator found that the truly sober living home used to be a care home under the zoning ordinance, and therefore would be a prohibited use in the R3 zoning district. We find this appeal challenge, or we filed this appeal challenging that interpretation as erroneous, arbitrary, and abuse of discretion. And we're asking the board to find that we are either a family or a group home that would be allowed in the R3 zoning district. If you can go to slide 4, please. I'm going to go through a few photographs of the property to show that we are a compatible use in this area based on existing development, zoning, and uses in the area. Please go to slide 5. So this is an aerial photograph of the Trulies condominium development. It was originally platted as 10 condo units. You can see that at the center of the site, it has a common open space area that has a pool, mature landscaping. And that was a key consideration for my client when purchasing the site, because it provides a very nurturing, beautiful environment for people that are in recovery. And that's important for them to have as part of that recovery process. Go to the next slide, please. This is a photograph from Wilshire Drive looking north, and you can see that the Ramada is there, and there is a screen fence as well as landscaping, screening the residents from the street and also providing a lot of walkability for neighboring residents. As you go to the next slide, this again is a photograph of the common space area with the pool in the next slide here. And this is a Ramada that was actually added by the Airbnb property recently. So this property was purchased a few years ago and operated as a short-term rental. And they built this Ramada. It allowed for a lot of parties, get-togethers. They had live entertainment that went on. And this is based on our conversations with surrounding neighbors. And so historically, this property has been very active with coming and going, people renting the property and then using that outdoor space. Next slide, please. The property has been completely renovated. Each condo unit has 2 bedrooms, 2 bathrooms, and you can keep going through the slides of the photographs. You can see that this is a very nice development, and each unit has its own kitchen where the residents cook and make their meals. If you can go to the aerial photograph. So this site is surrounded completely by multifamily development. You've got apartments to the north, the Wilshire Place condos to the east, the Continental Villa townhomes to the west, and then the McAllister apartments to the south. So again, completely compatible with the multifamily nature of the area. Next slide. This is a aerial photograph looking north from a drone. And again, it really shows the intensity of the multifamily development in the area. And again, there's a lot of screening along Wilshire Drive to add to privacy between the neighbors and the property. Next slide. This is a zoning map of quarter section 14-46 from the city of Scottsdale website. And as you can see, all along Hayden, there is R5, R4, R3 zoning. And then Hayden Road itself is classified as an arterial street. And so it's a very intense area of the city. Next slide. So now I'm going to address the appeal of the zoning administrator's interpretation. You can go to the next slide. I created these 3 columns because I thought it was very important to delineate each of the definitions from the zoning ordinance. You've got family, and my eyesight, I'm realizing, is not as good as I thought it is because we're going to cheat here. Okay, so for the definition of family, and all families are allowed in every residential district. You've got 1 to 6 adults. That's us. We've got 2 to 4 adults living in each dwelling unit. And you've got adults living as a single housekeeping unit. That's also us. And it has, as a definition of single housekeeping unit, you reside together, you share use of responsibility of common areas, household activities, meals, chores, maintenance expenses. And so we meet that definition of family all the way. The next definition is group home, and group homes are also allowed in the R3 zoning district and all multifamily zoning districts. And those dwellings are shared as a primary residence. Okay, that's us. But they have more than 6 adults in each dwelling unit. And because we only have 2 to 4, which again is less intense, we technically don't meet the definition of group home. As a group home, you don't provide any supervisory care. That's us. We provide no supervisory care. And supervisory care is a technical defined term in our state statutes and the zoning ordinance, which includes such things as with help with the self-administration, the administration of medication to the residents, help with the self-administration of medication to residents. There's none of that going on at the property. If there were so, the state would require us to get a healthcare institution license. But because there is no care, no treatment occurring at this property, we don't get a healthcare institution license. And I'll show you in a second a confirming email from ADHS to that effect. The other checkbox under group home is that the person must live in the dwelling for a minimum of 30 consecutive days. Our leases with disabled residents usually run between 30 and 90 days, so we meet that criteria as well. Moving on to care home. It's a dwelling shared as a primary residence. Check, that's us. No more than 10 adults with a disability. Check, that's us. The next 3, not us. We're not licensed as a healthcare institution under Arizona law. And again, a healthcare institution has about 22 subcategories. Sober living is not one of those categories. We have separate licensing requirements and a complete separate section of the ordinance. Of the state statutes, of the regulations. And again, it's because no care or treatment is being provided. Another checkbox says that you have to have on-site supervisory care services. I just covered that. We don't have those. And then there's another term of on-site other care services provided. Other care services is not defined. But again, we're not providing any care and therefore don't require that healthcare institution license. If you look at these 3 definitions in the zoning ordinance and you apply the most fitting definition to our use, we're either a family or a group home, and we should be allowed in the R3 zoning district. You go to the next slide. In fact, Michelle Sywick was before you in 2018, and she processed another interpretation. At that time, she had a care home at 68th Place between Cactus and Shea, and she was operating a sober living home with no care, no treatment, exactly the way we are. And it was described in her application, and that is exactly the use that we are, except we have less individuals per unit. And if you go to the next slide, Randy Grant, the zoning administrator, who's still the zoning administrator today, he took in that application and he deemed her sober living home to be a family. So what has changed? What has changed? The only thing that has changed is that now the state has a license for sober living homes. And I need to pause for a moment because there's been testimony from staff that sober living homes were licensed because they're providing care and treatment. That's not what the legislative history of sober living homes provides. Jeff Taylor and Michelle Sywick sitting before you actually were part of that legislative movement. And licensing of sober living homes came about as a result of what was happening in Prescott. There were a lot of bad operators up there. And there was a bill passed that was for Prescott at the time. And then it went to a statewide level. But what was intended to just handle the sober livings in Prescott to make sure that people were being treated fairly, that disabled people were in homes that were providing safe environments for them. That bill ended up being very discriminatory. And the way that Jeff Taylor has described it to me and Michelle Sywick has described it to me is that the licensing didn't come about because of care or because they wanted to protect neighborhoods. The ADA doesn't care about necessarily the community or the neighborhood. What they care about is protecting the class. They want to protect the disabled individual. And so they came up with a list of regulations and licensing requirements that require verifying sobriety. You can't put an individual out on the street. Like if they end up relapsing, you can't just dump them on the street. You have to then give them or transport them to a higher level of care. There's also spacing requirements, and all of those things were put in place as a licensing scheme for sober living homes so that first it protected the class, it protected the people with a disability. And then as a secondary effect, it also ended up protecting the neighborhoods. And so that was the purpose of this licensing scheme. And at first, ADHS didn't want to license them. They said, what are we licensing? There's no care, there's no treatment. Why are we licensing these facilities, these homes? It's housing, that's all it is. But eventually they came up with these regulations that arguably complied with the ADA. And it also provided a mechanism to protect the disabled class. And then as a secondary result, protect the neighborhood. You can go to the next slide, please. This is the email that I wanted to talk about, and it is at Exhibit 18 in the record. And this email was sent to me by Megan Whitby, who's the Bureau Chief of Special Licensing with the Arizona Department of Health Services. And she confirmed in red, highlighting, a sober living home license is not a healthcare institution license. She also cited to the statute and said, as you can see from subsection D, a sober living home cannot administer medication or provide any medical or clinical services on site other than conducting drug tests. And again, the drug tests are aimed at making sure that people are maintaining sobriety on site. I'm going to skip the next few things, but I do want to note that one of the reasons that staff deemed this to be a care home is because they can provide Narcan to individuals who relapse on the premises. And I want to note that we've submitted into the record as Exhibit 23, ADHS has recently come out with a standing order where anyone can get Narcan from a pharmacy without a prescription, and anyone can administer that drug to someone who's relapsed and who's overdosing. And that's part of the opioid epidemic. So it's not providing care to have Narcan on site and giving that to someone to save their life. It's something that's encouraged by everyone to do in the general public. So no care is associated with the administration of Narcan. And with that, I will step down and let Dan Lauber speak. Actually, I'll ask you, Chair, would you like to hear from Michelle next with regard to the sober living use, or our expert witness?
I mean, I guess it's kind of up to you. I'd prefer as best possible to partition the two cases, the zoning administrator appeal versus the accommodation request, but I'll leave it up to you how you want to do it, whatever.
I'm going to call Michelle up to give testimony as to what Truly's entails and what it does not.
Okay, hi, my name is Michelle Sywick. Can you pull up slide 57, please? I had part of my testimony to tell you everything that I've done in the community for the last 10 years, but I feel like I'm being rushed just a bit. So I'm just going to focus on what happens at Truly's. And I can't see that. Is it? Yeah. Okay. So after reading the staff interpretations and the staff reports, I think it's very important for me to describe what happens at a sober living and what doesn't happen at a sober living. The process has really opened my eyes to the misinformation and confusion surrounding sober living homes. And I'm hopeful that this board can see what we really are, and we are just housing. The same housing that families and group homes are able to enjoy in an R3 multifamily zoning district. So what happens at Truly's? Well, residents are sober. Residents want to live here and repair their lives and reconnect with their families. Residents live here for 30 to 90 days typically. Residents have already been through the detox and inpatient process. Residents are ready to live on their own in a supportive, sober environment. Residents are good neighbors. Residents have chores. Residents have curfews. Residents meal plan for the week. Residents go to the clinic during the day for groups and classes, and they are gone from Truly's from 7:30 a.m. to 4:30 p.m. during the week. They emulate a family and live with like-minded individuals, avoid isolation, where they can learn to interact and communicate and enjoy life again without drugs and alcohol. Residents cook together, clean together, and recover together. So what does not happen at Truly's? There are no medical or care services on site. There is no clinical services on site. There are no doctors, no nurses, or therapists on site. There's no detox or treatment on site. There's no assistance in the self-administration of medication on site. There is no healthcare institution licensed by the state at this site. There are no visitors at this site. There's no violent criminals or sex offenders allowed at this site. There are no resident vehicles at this site. There's no third-party housekeeping or kitchen or cooking services at this site. And there's no interaction with care homes in the neighborhood, which are assisted living homes or dementia homes. Our populations would not typically interact. I think that's probably where I want to end it, just in the interest of time. Okay.
Thank you, Michelle. And I'd also like to have Dan Lauber at this time address the board, Chairman.
Dan, whenever you're ready.
Thank you. I trust that I can be heard okay.
We can hear you.
Okay, thank you. I'll briefly qualify myself and then explain why the zoning administrator's opinion is in error. After 13 years as city planner, I went temporarily insane for 3 years and got my law degree from Northwestern. I've been specializing in zoning and fair housing law for community residences for people with disabilities for nearly 40 years. Most of my work is with cities and counties to bring their zoning into accord with the nation's Fair Housing Act. These include in Arizona, Phoenix, Maricopa County, Mesa, and Cave Creek, and Prescott, where I also, in addition to collaborating with City Attorney John Palladini on the zoning, also wrote a licensing ordinance. In Florida, which is really the epicenter of the sober home industry and the opioid epidemic. I've worked with Palm Beach County, Delray Beach, Pompano Beach, Oakland Park, West Palm Beach, Lauderhill, Wilton Manors, and a number of other cities, and with cities across the country. My work's been cited numerous times in the packet of materials submitted to the Scottsdale City Council in December of 2017. So city staff likely had to be aware of the proper approach to zoning for community residences, which is a broad category that includes what Scottsdale has uniquely done, divided them into care homes and group homes. I wrote the model zoning for the American Planning Association and the American Bar Association in a law review article that's still being cited 25 years later. Conducted trainings, workshops, and sessions for HUD, the nation's state mental health attorneys, planners, attorneys, literally from Alaska to Florida, and was principal author of the American Planning Association's successful amicus brief in the city of Edmonds versus Oxford House before the U.S. Supreme Court. I have served as president of the American Planning Association, and I'm probably the only person dumb enough to serve twice as president of the American Institute of Certified Planners. And I should add, way back in 1974, and this will be relevant to the second hearing tonight, along with Jack Noble, we created the idea of a spacing distance between community residences. Now, the zoning, after very careful examination of the zoning administrator's decision, I've got to say it seems awfully arbitrary, capricious, and runs afoul of the nation's Fair Housing Act. And let me explain why. Let's start with page 2 of the City Council report dated December 5th, 2017, where it just outright says the new ordinance that the city would be adopting would limit family to 6 adults and their related independent children. And then on page 3, it recounts that HUD cited the city of Prescott for burdensome restrictions on group homes for the disabled, and Prescott since amended his ordinance. Now, I wrote those amendments in collaboration with City Attorney John Palladini, and one of the things we did, which so far it seems Scottsdale doesn't quite understand, is that we complied with the well-established legal principle by the vast majority of court decisions that when the number of people living in a community residence for people with disabilities, a care home or a group home under Scottsdale's definitions, does not exceed the number of unrelated people that constitute a family in the zoning ordinance's definition of family, it's got to be treated the same as any other family. The locality cannot impose a spacing distance between these care homes or group homes, and it cannot even require, the city cannot require that they get a state license or certification. Page 4 of the City Council report says basically that because of settled law, the city may not impose more restrictions on homes where people recovering from substance abuse live than it does on families, seemingly recognizing, at least in part, the legal principle. It then goes on to say on page 5 that the state statutes provide a benchmark of what should be considered a family with regard to establishing zoning regulations. And that benchmark is that a residential facility, care home or group home under Scottsdale's definitions that serves up to 6 people, quote, shall be considered a family for the purposes of any law or zoning ordinance which relates to the residential use of property. Just these statements alone in the history of your zoning ordinance amendments adopted in early 2018 directly support an interpretation that 2 to 4 disabled adults living in a dwelling unit, and remember the Trulies consists of 10 dwelling units, must be considered a family under the Fair Housing Act and Arizona law. Back in 2017, the city of Scottsdale did not have a cap on the number of unrelated people. Consequently, it really couldn't legally zone for care homes or group homes at all, because that would be discriminatory on its face. In fact, the City Council report of December 5th says the zoning ordinance is proposed to be amended to be consistent with the aforementioned state statute and set to limit the number of people that can live in a single family residence and still be considered a family. Now, one thing it's missing is that your definition of family applies to all dwelling units, not just single family dwelling units. It would be blatantly illegal if it did apply only to single family. It applies to multiple family dwelling units as well, which is exactly what the Trulies consists of, 10 multiple family dwelling units. The City Council report oddly did not provide any hints as to what conceivable basis there was to limit care homes to single family districts and group homes to multifamily residential districts. And quite honestly, there's just no rational reason I can think for treating them differently in your code. So to tie this all together, the city, in its December 5th report, the City Council was told, cited a 2-page piece I had written, which summarized the maximum zoning restrictions a city can impose on community residences for people with disabilities. And could you please put slide number 59 on the screen there, please? It should show a bit of a flow chart which will help this make this clear. If you meet the definition of family and each dwelling unit in this property meets the definition of family, then it has to be allowed as of right as a family. It seemed to me that the zoning director recognized this at the bottom of page 2 of his opinion, when he writes about each dwelling unit can house 2 to 4 people, as is arguing that the Trulies isn't a group home. So he's trying to sort of have this both ways. And I don't see how he can do it. Plus, it's disingenuous to suggest this is a community care home because the license it gets is not a healthcare institutional license. The zoning administrator says in his report that they rely on the state's expertise on licensing. And the state's expertise on licensing in Exhibit 18 is very, very clear that the license it issues for even an aggregation of individual units housing people in recovery is not a healthcare institution. So the point is that each unit falls within the definition of family. It's only when you have more than 6 people in a dwelling unit that you could have a care home that would require spacing or could be limited to different zoning districts. As long as each of these units meets the definition of family, and they do, they've got to be treated the same as any other family. Otherwise, it is facially discriminatory solely because they're people with disabilities. A different standard is being applied to them. Correcting this error would not invalidate the treatment of all sober homes in Scottsdale. The corrective zoning interpretation of the zoning code would only affect sober homes that house 6 or fewer people. Those that house more than 6 still can be, you can still go ahead and apply your care home and group home definitions to them. The bottom line is that for zoning purposes, the law is extremely clear. Each of these dwelling units is a family. And the case law under the Ronald Reagan's Fair Housing Amendments Act of 1988 makes it very clear that the city is pretty much obligated to overrule the zoning administrator's decision is contrary to the city's own zoning ordinance definition of family and the law of the land. Treating them differently simply because these are people with disabilities, which is what the zoning administrator proposes, is simply blatant discrimination on its face, despite the contortions the city staff went through trying to justify the zoning administrator's plainly erroneous position that falls well outside established case law on this specific question. And when a zoning administrator's position is so out far afield from what the case law is, it can only be characterized as arbitrary and capricious and an opinion that flies in the face of our nation's Fair Housing Act, abusing the zoning administrator's discretion. Thank you very much. I'd be happy to answer any questions you might have. I did skip a few things because of the time constraints.
I just want to clarify, because I don't know that we're clear. My name is Sarah Jane Hunt. I'm co-counsel for Ms. Dukes here. Was it your intention to have the reasonable accommodation presentation at this time, or would you like to wait and address the issues of the zoning?
I wanted you to go ahead and do everything right now. I gave you 30 minutes total for the whole shebang. So wrap up what you got and
Sure.
then we'll be done with your presentation for the night.
Okay, so my name is Sarah Jane Hunt. I'm a fair housing attorney. I represent individuals across the country who provide housing for people with disabilities like the applicant here. In addition to your zoning ordinances, this city, like every city in America, is subjected to the requirements under the Fair Housing Act and the ADA. And under those laws, those federal laws, the city is required to make a reasonable accommodation for individuals with disabilities if that accommodation is necessary for them to enjoy the housing of their choice. You've kind of limited us to 2 minutes, so I'm not going to go into all of the case law. There was an email sent to the zoning administrator and council for the city on September 16th, 2021. That lays out our legal basis for the request for accommodation. I assume you all have had the opportunity to talk with your lawyers and go through that.
I will tell you at this time that this accommodation is necessary. People with substance use disorder, that affects their life, that affects their ability to learn, their ability to engage in the community, their ability to work. In order to ameliorate those symptoms, they have to have acceptable housing. That housing needs to be in a community. They need to learn how to live again, how to go to work again, how to engage with their families again. And doing that on the outskirts of town or not in this town at all is frankly discrimination. The accommodation is not unduly burdensome. There is evidence in the record that we have submitted. We have experts here should you wish to talk to them about the impact of parking. There is none. The impact on public services, there is none. And the impact on property values, and you would see from Exhibit 20 that the property values since the applicant has occupied the property have in fact gone up. Those individuals are here should you wish to question them. If the applicant closes, there will be irreparable harm to the residents. They will be homeless. They might have to go live with people who do not support their sobriety. They may end up having to be institutionalized. That harm is far greater than any of us can imagine. And for that reason, we ask that you, under the Fair Housing Act and the Americans with Disabilities Act, grant this reasonable accommodation. Thank you.
Thank you. Is there anyone want to speak for 30 more seconds? Otherwise, let's, Ms. Dukes, do you want to answer a few questions? And I think initially, help me walk through the situation. When the city decided to base its definition of a care home on state healthcare institution licenses, the state already had healthcare institution licenses in place at that time. Is that right?
Yes, you're correct.
And that would be this, I take it, Chapter 10 of the Arizona Administrative Code that we received healthcare institutions licensing.
Yes, you're correct.
R9, 10, 102, healthcare institution classes and subclasses, and there's a whole list of 26 different types of healthcare institutions.
Yes, you are correct, Chairman.
And at that time, when the Scottsdale made that amendment to the ordinance, basing its definition of care homes on state healthcare institution licensing, under no circumstance would this use need any kind of license, let alone any kind of, there was no licensing requirement, period, right?
Correct. At that time, there was no licensing requirement for sober living homes.
And then I guess a year or two later, the state decided to add a different type of licensing separate from healthcare institution licensing for sober living homes.
Yes, you're correct.
And that's in this completely other, now we're in Chapter 12 of the Administrative Code for sober living homes. It's completely separate. A different type of license.
Yes, you're correct.
Any other questions for the appellants? Go ahead.
I just have a general question. Why is it that you need a license if we're just a family-run home?
So again, it stemmed from the issues that were happening in Prescott. There was an infiltration in sober living homes being open because we had an opioid epidemic that happened, 2016, 17, 18, and it's continued on since then. But essentially, sober living home opportunities are part of the recovery process. People detox, they have inpatient facilities, they have outpatient facilities, and then sober living homes are kind of that last step between them being back, just living their lives. And the whole purpose of the licensing was, again, to make sure that the disabled class were being treated fairly. Some of these operators were fly-by-night operations. They would take the people's money and then put them out on the street. There was some issues with neighbors. And so That's when the state legislation started to be drafted to address this issue that was happening in Prescott. It wasn't because any care or treatment was being provided. It was at first to protect the disabled class. And now it's evolved into ADHS having the licensing when, and Michelle can actually come up and talk because she was part of that legislation process, but all along ADHS did not want to have to license these uses because again, no care is being provided. And in fact, one of the exhibits that we submitted is when there's no care being administered in a home for 12 consecutive months, like if ADHS sends out inspectors and they determine that no care is being administered in a home, they'll actually revoke the healthcare license. Like you have to be providing care and treatment to have that healthcare institution license. And so that's one of the exhibits we submitted to demonstrate that when you're not providing care, you're not providing treatment, you don't get this healthcare institution license. And I think I'm kind of drifting away from the question that you asked, so I apologize. But again, the sober living licensing initially occurred because of the issues that they were having in Prescott.
So what if we just didn't get a license? You know, what if that just happened? And this was just an apartment complex that Michelle owned and she rented it out. And none of these people even knew that there were people going through their sobriety in this facility. Like many of us have rental properties.
Right.
We don't know what people are doing in these rental properties. So we're here asked to determine if this is a care home. And because you have to get a license, we have to determine if that license considers you as a care home. But what if you just threw the license out the window and you just use this facility for what she needed to use it for and take care of people? Is that not possible? I mean, I just don't understand where the licensing is necessary because of Prescott.
Yeah, let me have Michelle actually address that because she was part of the legislation and being part of the Arizona Recovery Housing Association, she definitely knows the answer to that question.
Okay. So that's a very valid question. It's actually illegal in the state of Arizona to operate an unlicensed sober living home. So when they passed the rules, when DHS passed the rules, there are some steep penalties if you operate unlicensed. So in the application, I think your question is super valid and I would really like to do that, except it's against the law. There are sober living homes that operate without a license because they would like to go unnoticed with the city. On the application that I submitted to the state, there's a section of it and it says it's a separate signature block. I have to type my name in there and it says, I attest, Michelle Sywick, that I am in compliance with all building and zoning codes of my local municipality. So I literally can't sign that application to get a license because I did the right thing. I went to the city and I said, this is what I'm going to use Trulies for. And it's been interesting ever since.
I have a follow-up. Can I keep going? All right, so can we put up the slide that showed the facilities with the R3 and R4 zoning? Michelle, can you stay up there? I want to ask you about this.
So
want
that
the map?
is-
Yeah, that map that had the other, where your facility is, where it's R3 and then how close the R4 is and.
Slide 14.
Right. So you run other facilities in the city of Scottsdale, correct? And those are obviously not in R3 zones.
Correct.
So my question is, and this is just for me, this isn't really about trying to determine if this is a care home or not. Why did you purchase a unit in an R3 zone when you knew that R3 zoning wasn't going to allow you to get a permit?
Great question. I am more analogous with a family and a group home than I am a care home. It just as a layman, you pull up that zoning ordinance, you read the definition of a care home, there's no possible way that fits a sober living home. I'm not licensed as a healthcare institution. I do not do assistance as self-administration of medication. That's a license. Like that's serious stuff. We don't provide care at the home.
No, I get it. I guess my point is that knowing that R3 doesn't allow for what you want to do, but you could easily move to R4, R5, purchase whatever you want in those areas and be able to walk right in and run your business. I just,
Oh, no, I couldn't, no.
no,
The intent,
care homes aren't allowed in.
no,
Fine.
they're not. The intent of.
So I need
the-
some clarification on that.
Yes, Chair Kaufman, Board Member Chacron, the care homes are permitted in our R1 single family zoning district.
I'm sorry. Okay, R1. I'm sorry. So there are other areas within Scottsdale that we could put a care home. For my clarification, at least. Right?
So they are allowed in residential neighborhoods. There's a spacing requirement that what the city council voted on in 2017, going from 700 feet to 1,200 feet in an already saturated city of Scottsdale assisted living community. So you're literally, if you won't allow people with disabilities to live in a multifamily neighborhood, and you're literally squeezing them out of single family neighborhoods, where in the world is this disabled class going to live?
Okay, thank you.
Any other questions from the board?
Just had one question. It's in regards to the licensing. Is your intention to get one license for the whole property, or is each individual unit going to have separate licenses?
Well, I actually don't know because they won't accept my application because I won't sign that attestation with the compliance with zoning and building codes.
So I guess the answer is we don't know yet. It's whatever, in submitting that application to the state and getting their determination, whatever they decide, if they want it per unit or if they want it as the entire property, because it is platted as one condo plat. We'll do whatever the state requires in terms of licensing.
All right, thank you. See any other questions from the board? Oh, Ms. Board Member Gonzalez, go ahead.
On licensing, I'm a little unclear. The licensing, as I understand it, sober living is not a health care license. What is a sober living license? Is that a separate license specifically granted by the state, or is that a license included in some other category of licensing?
So it's actually a special license. And that's why when I sent the email to ADHS, I got a response back from their director of special licensing. Special licensing covers a lot of different licenses. That's not just housing in this instance. It could be cannabis. There's a bunch of different categories. And so sober living has its own special licensing category by the state. It's not healthcare institutions. It's an actual special license that they approve for each sober living home.
Okay, but that's a state license?
It is a state license.
Okay, so the license of a sober living is state mandated, but is it a kind of an industry requested licensing? You talked about Troubles in Prescott and other places. So is this a license that the industry has asked the legislature to post to be self-imposed on sober living homes? Or I'm not quite sure exactly. And I know you want to protect the public from unscrupulous operators.
Right.
Is that the entire reason behind the licensing, a separate licensing for sober living homes?
Yeah, the primary purpose was to protect the disabled population. The secondary intent was to make sure that they were being operated in a way that made them good neighbors, to the community. And I think at first, and Michelle can correct me if I'm wrong, at first the sober living home community did not want to be licensed by the state because, again, they weren't providing care or treatment. But as discussions continued at the state level, the Arizona Recovery Housing Association was formed, and that's a self-certifying agency that goes in and inspects these facilities and gives them a certification. and Michelle has been on that board, the industry then came together and helped create the rules and regulations that apply to sober living homes.
Okay, now, just as a follow-up on that, there's no health care and no on-site supervision. But if well, I think one of your slides said that one of the things you have to do is confirm that there is sober living there and no use. Administratively, how do you do that if there's no one on site to monitor the activities that go on there? I'm just curious on how you do compliance if there's no one there.
So let me clarify. The term that's used in the definition of care home is supervisory care services. It's not just supervision. Supervisory care services is a defined term, and it includes things like assistance with the self-administration of medication. So it's care with her staff providing some supervision over that.
Yeah, but what my question was if there's no on-site, how do you make sure that the occupants of these apartments are living by the rules of the sober living license? I mean,
so there are staff.
How do you know they're not cheating or violating the rules under which your license is being granted or observed?
So there are staff on site. There's 3 shifts. There's typically about between 2 and 4 staff members on site, 3 shifts a day. In the morning time, because the residents don't have vehicles on site, there's 3 passenger vans, and the staff take the residents in the vans to their classes for the day. They have yoga, they have job training. It's all off site. So it's like basically like people going to work or school during the day. They're gone every day from 7:30 to 4:30 at a different location, taking these classes and bettering themselves. The staff then bring them back to the property in the evening. They all cook dinner together in their units. They clean their units. They get ready for the next day. They go to sleep. And that is their schedule Monday through Saturday, essentially. Sunday's their free day, but there are staff on site just to provide, they answer questions. They make sure that, the chores are being done, that everyone's abiding by rules, because these sober living homes have rules, just like any family would have rules. They have rules as well. And part of them are required in the licensing scheme that the state mandated.
Okay, because I got the impression that there was no supervision or any on-site personnel. And now you're telling me there is a staff to help
Correct.
So there is staff on site, but they're not supervisory or
There's no care, supervisory care.
there's no care, but they act as chefs, you say sometimes?
Did you say chefs?
Did you say they actually chefed for some of the units?
No, they cook their own meals, and they go grocery shopping periodically through the week, make grocery lists. So they cook all their meals, they do all their cleaning. There's no outside cleaning or laundry or cooking services at all.
Okay, the staff just basically supplies transportation and.
Correct.
Okay, thank you.
All right, any other questions from the board? And I guess with that, we'll move on to the public speakers. And we got a pile of them here, so if you guys want to maybe. Yeah, oh yeah. Do you guys want to take 5? Anyone else? We can adjourn for 5 minutes. Yeah, why don't we do that? Let's adjourn for 5 minutes unless anyone objects.
Rose, can you hear me?
Oh, I'm unmuted.
There you
Can
go.
you
I
hear
can
me?
hear you. Yep, I can hear you now.
Sorry,
Perfect.
technologically challenged.
That's okay.
Do these events always go on so long?
Yes.
Okay, maybe that's why I haven't been attending any in the past.
All right, I'm gonna go ahead and mute you because everyone can hear us.
Okay, thanks.
I know what you're up
They should have done it in 2017.
I know what you're up for. Are you gonna talk?
I signed my time here. They called us in. That's gonna ask if you get a chair, you sign your plan. Any phone call with him, you don't, you're like, you know, I'm trying to be. One way or another, right?
All right, I think we're about ready. If you guys want to resume your positions. Now for the speeches, the max for each person is 3 minutes. And if you could keep it to quite a bit under that, I'd appreciate it. So you don't need to fill up 3 minutes. Try not to repeat things that people have already said. And if you don't have much to say, just get up, take 5-10 seconds, say your name and why you support or against us real briefly. And then we're going to start at a request from David Cash to go first. I think he had to get home with his son or daughter or whoever that was. If you want to go ahead.
Good evening.
And if you could give us your name and address on the record.
Yeah, David Cash, 7742 East Vernon Avenue. Not a public speaker, but I am a father. I haven't had my statements or testimony reviewed and rehearsed in front of a very savvy attorney. So I'm going to speak from the heart. This potential sober living area is extremely disruptive, has been disruptive already. I mean, they're already operating. As any permanent resident of the community would tell you, we've seen an uptick in drifters and vagrants and strangers, just suspicious activity. There's been a rise of that within the community. I respect everyone's journey, where they came from, what they're going through. But the reality is they have baggage, and that baggage comes in the form of, you know, maybe pimps that got them addicted, or, you know, they're drug dealers or whoever, but those individuals do not let go easily. And because they do not let go, they will try to access those individuals. And the staff is not a security staff, it's a monitoring staff. So as they see, or as those individuals will lurk through the community, my community, to try to get a glimpse or access those individuals, that puts my family at risk, that puts my neighbors at risk. When I spoke to Michelle, she did admit that in some of her other properties, there had been drugs left around the property for residents of her facilities. And in my community, that could easily mean that a dog's going to ingest that. Right next door is not a multifamily unit. It's you actually have two families that live next to there one of which has 5 kids, 2 of their own, 3 adopted. And the fact someone may be lurking around their perimeter, trying to find a drop spot for drugs is absolutely terrifying. So I guess in conclusion, I would say also want to bring up when they're searching for a reasonable accommodation, there are absolutely no accommodation for the disabled on the property. There are no handicap parking. There's no accessible facilities or accommodating there's no reasonable accommodations for disabled persons within that community.
Your time's up. Thanks.
Thank you.
Let's move on. Colleen Vorst.
Hi, I'm Colleen Vorst. I live at 7722 East Vernon Avenue. I'm right in the Continental Villas East 2. And I just want to say that I support the original decision of the board members to decline the request, the owners to build the Scottsdale Recovery Center. I oppose the building of it for the following reasons. First, the neighborhood is obviously a residential community. It's not a place for a halfway house or a medical facility. There are plenty of medical facilities available or R1 areas in Scottsdale. I support the rehabilitation of drug users, but a center like this does not belong in the middle of our neighborhood. Patients may include individuals who are current substance abusers, as well as persons mandated by a criminal court to receive care. This may lead to increased crime in our neighborhood. We also have many children in our neighborhood, including my 2-year-old son. I fear that their safety will be impacted if this facility were built. The building of this facility may affect the financial value of our homes. Transient population would also affect the feel of our close community. Second, the site location is not a good one. It's located on an already crowded street with many people who park along that street. Sometimes it's dangerous to even get through there. And a 10-unit facility with multiple people in each unit would bring more traffic to the area, would cause major congestion along that small street. This would affect the walkability and the traffic patterns in our neighborhood and also along Hayden. Again, I am for building a facility like this. I think it's a really awesome idea. I just don't think the middle of our neighborhood is where our kids play is the best place for it. So, thank you.
Thank you. Jeff Marsh, do you want to go ahead?
Jeff Marsh, 28 South Olive Mesa. Yeah, thanks for everybody. Thanks you guys for taking the opportunity to have us here. I want to introduce myself. I'm the executive director of the Arizona Recovery Housing Association. We are a nonprofit, membership-driven organization that sets the bar and the level for sober living homes in Arizona. We are a affiliate of a National Alliance of Recovery Residences, and which is that there's 32 states that belong to this, and they set the direction of how sober living should operate. The membership has 65 operators, 1,500 beds, and 250 houses is what we represent, all the way from Northern Arizona all the way to Tucson. We are the only ones that are allowed to inspect houses other than the state of Arizona, and the state of Arizona accepts our certification in lieu of their inspection. That was granted under the 2017 and 2018 laws that have been discussed. Michelle has been a member since 2011. She's been a member for 10 years. She's been very integral in adopting the ordinances, along with setting our rules and setting how we investigate and certify sober livings. She has never, in any of her properties, she has never had a grievance or a complaint in those 10 years. And just the base of it is that we need to have more sober livings. We do not have enough in the state of Arizona. There's a major need for sober livings in Arizona. And I understand the not in my backyard, but that's why they created federal housing laws to prevent people from not allowing drug addicts and alcoholics who are in recovery from attaining housing, right? It's what happened in the 50s and the 60s with race, right? It happened in the 80s and 90s with gender. It's basically discrimination against alcoholics and addicts that are in recovery. So that'll pass. Thanks.
Thank you. Lala Smith.
Good evening, board members. My name is Lala Smith. I'm with eXp Realty. I've been in real estate almost 2 decades, and I am top 1/4% in Arizona and top 12 individual agents as far as production. As a resident of Scottsdale, I'm very, very proud to live in this city. I lived globally, internationally, and I find Scottsdale one of the top cities in the world, and I'm very proud to say that. When I heard about sober living from Michelle, just like many of us here, my eyes were open, my ears were listening. It sounded not as pleasant, but then I got to educate myself on it. And I was very pleasantly surprised that, to me, it is a better option than having this multi-unit complex occupied by Airbnb users. Why? I own Airbnbs. I own rental homes. Sadly, like you said, we don't know what our tenants do in these residences. I cannot be there every day supervising. I'm very proud to say with my Airbnb manager that I'm a co-host, so I can monitor who goes in. I have cameras. But even then, people bring in substances. People throw parties. I have a strict rule, no parties after 9 p.m. Be mindful of the residents. I have been forced to sell my investment properties because I did not want to be ashamed to own them next to the full-time residents. Now, why will this not change? If we look at the sold since January, okay, we had 212 apartments sold. Out of 212 multi-complexes, only 169 could not get financing with FHA. What does that mean in simple words? The FHA or government financing would not lend on these units because most of them are owned by an investment individuals, and the ratio on investment units is very high, meaning we are going to have tenants or STRs, excuse me. Now, but Michelle educated me, and I'll be very brief, that her residents have to go to classes from 7:30 a.m. to 4:30 p.m. So I'm thinking they're going to be well spent with their energy. Sadly, as the first gentleman said, we cannot control who comes to that complex. So maybe the supervision could be better as to that stance. But I firsthand have not gone through a sober living, but I have had virtually a dozen clients that have either lost their children or B, lost everything they owned in their life because there was no programs like this. I know it doesn't sound pleasant, but when we look at the alternative, would I rather have a renter that can bring any substance, throw any party, or have a quiet living where they don't have a vehicle? There's no crowded parking because there's vans for transportation, and we're creating better lives for these individuals. It just makes me happy to see somebody get a second chance. Thank you.
Thank you. Tove White. Oh, about parking. Does anyone have any questions about parking? Lynn Reed.
Hi, my name is Lynn Reed. I live at 7908 East Wilshire Drive. My property is 7906. It's a home with a casita. The home 7906 is where my daughter lives. I've been at that home for 28 years. I've seen plenty of traffic and a lot of building going on in the area, lots of medium density housing going on, and that traffic is greater than what I'm seeing next door. The traffic they have comes, like it has already been covered, in the morning and in the evening. I've been outside when they're coming and going. I don't hear a lot of ruckus. I've heard conversation. I don't see anything about what's going on next door that disrupts my community. I have had no problem personally or publicly at any time of day. The other day I heard a whoop that sounded like a cheer for a sports game of some sort. Nothing different than I hear from the apartments behind me. I don't find anything offensive about this community that would offend or disrupt our neighborhood. I think that it's an asset in that it's building people to live wholeheartedly in the community. It's already been covered that the agency that runs this residents have requirements for the residents to pass through 5 or 6 different levels of recovery before they're even given the privilege to have their own residence. And I think that's something that our community needs more of, and I am in support of it. So I appreciate your time.
Thank you. All right, next. Is it Jeremy Alv something? And you're on top of this huge stack of probably 30 or 40 blue cards.
Does that mean I get more minutes?
You're proposing to speak for all these people, is that right?
I'm going to be speaking for a lot of people from.
Okay, then we'll give you the max 10 minutes. I think this gives you that right, and go for it.
I don't think I'll need 10 minutes, but thank you, Mr. Chairman and the board, for allowing me to speak and being able to speak up on behalf of so many people that are here today.
Can you get a little more on the mic? Thanks.
Sure. Sorry. I'm grateful for the opportunity to speak to everybody about my experience. Let me give you a little background about my experience. I'm a physician. I
apologize for interrupting. Could you into the microphone give us your name and address?
Oh yeah, my
Thank
name
you.
is Jeremy Alvord. I live at 9158 West Villa Hermosa. I'm a physician trained at Mayo Clinic. I currently have been working at Mayo Clinic for the past 8 years, taking care of the residents of Scottsdale. In early 2020, I developed testicular cancer, had surgery from that. Also was sent into the COVID ICU unit as a anesthesiologist during the pandemic. There, I took care of patients dying from COVID for about 3.5 months. Along with that, had 3 or 4 more surgeries on my own, had multiple people die, not only in the operating room from liver transplant anesthesia, which is my specialty, but had to deal with patients and family members dying from COVID during this pandemic. During that time, I did not cope well. I was overworked, I was burnt out, and I was being pushed to the limit. I chose to make a bad choice. And that choice was I used the prescription medication that was given during these surgeries, and I became addicted to those medications. I did not get them from drug dealers. I did not go on the streets, but I am an addict and I needed help. When I went to this prestigious institution that I work for help, they had nowhere to send me. And Scottsdale Recovery, I found Scottsdale Recovery and they were able to accept me. How my journey went from there is I went to a detox center in Chandler, Arizona for 3 days to make sure that I was safe, that I was not withdrawing from drugs, that I would be okay to be in a facility such as Truly's. After 3 days of the detox center, I went to Truly's and stayed there for 30 days. I was a person living there with no more than 4 people in every apartment. I was an active member, did yoga every morning and worked on my recovery and myself. I have 4 children, 5, 7, 12, and 14 years of age. I left them for 30 days because my addiction was so severe that I needed to be able to work on it because my disability that I had developed, it ruined my relationship with my wife. It inhibited my ability to be the physician I needed to be for the people of Scottsdale and the world. And it was not the person who I was before. Before age 36, I had never even drank alcohol. I had never used any drug. But because of the situation that I found myself in and not being willing to ask for help and get the counseling I needed, I fell upon drugs and that's how I coped. But I was able to get help with this facility. While I was there, everything that has been outlined by everybody here is true. I cooked my own meals. I cleaned and scrubbed my own toilet. I was an active participant in all the activities at the center that I was not ever giving counseling. While I was at Truly's, I never saw a nurse or a physician ever take care of a another person or give medication to somebody that needed it. We were an active group. We helped each other and supported each other while at Truly's. We talked about recovery and we helped each other. And just a little bit of statistics behind this. 21 million people in the United States suffer from addiction. Only 10% of those people get help. So these vagrants and people that you may see walking around the streets are those people that aren't getting the help they need. May not be associated with anyone that's actually actively getting help. It costs our country $600 billion a year because of addiction. That's not only addiction from people you see on the streets, that's active addiction from people that are contributing members of society, missing out on work, me not being able to provide services to the people that need it. But from my ability to be able to go through the program, and I'll be graduating from the program and actively working as an anesthesiologist, I owe that opportunity from which I gained this insight from Scottsdale Recovery. And many of these people that I see standing over here, they helped me realize that I needed a reset in my life. In order to do that, I needed a place like Truly's to be able to live, understand what I need to do differently, and be able to have the tools to go back into this work environment that we're still currently dealing with. And I'm very thankful for the opportunity to speak to everybody here. And with that, I'll close.
Thank you. And the last two cards I have are Heather Dukes and Sarah Jane Hunt. Are you guys proposing to? Well, preferably, we don't want you guys to speak during this period.
I'm just going to come to the mic so you can.
Chair Kaufman and board members, sorry to interrupt. We also have one more speaker who's logged in telephonically on this item. If we could also hear those comments at this time.
Sure.
I believe it's Rose Cortese who's on the line.
I just wanted to clarify that we would have an opportunity for rebuttal.
Rose, whenever you're ready.
Go ahead, Rose, and then we'll handle the other issue.
Can you hear me now?
We can hear you.
Thank you. My name is Rose Cortese. My family lives at 7909 East Wilshire, right across the street from the Truly's. First, I'd like to thank the board and the very helpful people who work there. I couldn't have done this without your help, so thank you. I appreciate the doctor's comments before me. I'm so grateful that there was someone there to help him. However, Scottsdale Recovery Center uses the Truly's as one hold site. This is not separate units or families. There is a supervisor on the property 24 hours a day. These are not families or roommates. This is not about fair housing, but these are complete strangers who are told to share a bedroom. They are taken out in vans to receive treatments, according to what the owner told me one day. And, I'm very pleased that they're getting out there and doing things all day. But the clients are not permitted in and out access of the property. They are controlled 24/7. No one can visit, but there's nothing to stop someone from going up to the fence. So currently, on the weekends, Scottsdale Recovery Center did try and keep the quiet down. It had been getting very loud, and being right across the street, it was hard to keep windows open because we would hear the movies, the ruckus, the enjoying of the Sunday very loudly. And it had been early in the morning as well. I'm told that they will be doubling the number of people to 48 people in those units. And that will double the amount of noise, no matter how hard they've worked to keep it quiet. I'm glad some people aren't bothered by the noise or the activity. We can't open the windows or be out on Sunday because it's noisy. The owner confirmed during a meeting that 80% of these clients relapse. 80%. I mean, a 20% is as good as a placebo. I'm not quite sure the business model. So to go on, the Social Security Administration does not see or call addiction a disability. The American for Disabilities Act protects fair housing, but it protects alcoholism for sober people. It does not, I'm sorry, I'm not an expert in that field.
Yeah, you're
But
running
I
out of
can't-
time. If you could wrap it up very quickly here.
Okay. Scottsdale Recovery Center is not an individual. They are a business and they want to claim unfair housing. They opened a business without a permit. Any
We're gonna
harm
have-
that happens to these poor
Rose, we're gonna have
people-
to cut you off here. You're going on to a whole new
Okay.
point. But,
Okay.
Thank you for your time. And then, yeah, we do have accommodations for rebuttal in our bylaws. So if you want to go ahead and keep it to maybe 5 minutes or so.
Sure. I'd like to address the various comments that individuals who are in recovery are not disabled. That is not true. What the definition of disabled is not public opinion. It is in the Fair Housing Act and the Americans with Disabilities Act. And what that is a physical or mental impairment that substantially limits more than one major life activity. HUD has also gone on to say that this includes, but is not limited to, diseases and conditions such as drug addiction and alcoholism. There is no question that individuals in recovery are covered by these acts as qualified individuals with disabilities. I'd also like to remind the board that in your analysis, not just under the zoning ordinances of this city, but again, your obligations under the Fair Housing Act and the ADA are such that you cannot deny a reasonable accommodation based on the stereotypes and unsubstantiated fears of neighbors and property owners. That would be a clear violation of both of those acts. Such stereotypes include calling individuals in recovery vagrants, transients, who attract pimps and drug dealers with no actual evidence in the record of any such thing. I would also like to remind this board of the fact that, as I mentioned earlier, the impairment can be physical or mental. It does not require a person to need a ramp. It does not require a person to need a specialized parking space. And actually assuming as such is in itself discrimination. I also heard many statements about the applicant being a medical facility or a halfway house. That is not what they are, and the evidence in the record supports that. This is not a facility. This is not a care home. This is a home in which 2 to 4 individuals live. If they were not disabled, we would not be here today. Because the applicant is not a care home, the spacing requirement should not apply. Treating the applicant as a care home is discrimination on its face under the Fair Housing Act and Americans with Disabilities Act because it treats a home occupied by 2 to 4 people with disabilities differently than a home occupied by 2 to 4 people without disabilities. However, even if this board finds the applicant operates a care home, the board is still required to make a reasonable accommodation to individuals with disabilities if that accommodation is necessary. And I would like everyone to listen to this part, to afford people with disabilities equal opportunity to live in the housing of their choice. People with disabilities get to live where they want, just like you get to live where you want. We don't get to restrict where they live simply because they are disabled. Under the ADA as well, the board must grant a reasonable accommodation if the accommodation is necessary to avoid discrimination. Absent any undue burden, financial burden, which this board has not raised any issue of, or there's no evidence of the record of that, the accommodation should be granted. And on that, I would like to say thank you for your time. I know it's been a very long night, and I appreciate your attention. Thank you.
All right, thank you. I think that's all we have. Now it's up to board discussion.
Chair Kaufman and board members, if I may, the zoning administrator has requested to address the board if you would allow him to speak for a few moments.
Yeah, if you could keep it short, 3 to 5 minutes. Go ahead.
Chair Kaufman, members of the board, I'll take much less than that. We are very interested in preserving the rights that we think we have under the zoning ordinance, but we recognize that there are some things we need to bring into alignment with the state law. So what I would offer up as a solution to the conundrum that we have this evening is, if you act on the reasonable accommodation first, we would support that. Then we don't have to hear the interpretation. We don't have to act on the interpretation. I'm just offering that up. The applicant is interested in that and believes that gets them where they need to go. And I think it helps us in terms of allowing this to occur without having the zoning ordinance attacked. Thank you.
Thank you. All right, so we're gonna stick with the zoning administrator appeal, and we're gonna have board discussion. I think first, did you want to make the motion,
Yes.
Vice Chair Matt?
Thank you, Chair Kaufman. Regarding the appeal of the zoning administrator's interpretation, I would move that the first two items, that this body has jurisdiction and that the applicant has standing, are clearly established, and we have no issues with those. So I would move that we have jurisdiction and the applicant has standing.
I'll second that. Can we have a roll call vote, please?
Chair Kaufman,
Aye.
Vice Chair Metz,
Aye.
Board Member Gonzalez,
Aye.
Board Member Chacron,
Aye.
Board Member Wagner,
Aye.
Board Member Didi.
Aye.
Thank you.
All right, with that out of the way, I think we're now ready for board discussion and then presuming a motion. My feeling on this is that the definition of a care home in Scottsdale requires a healthcare institution license. There is a specific healthcare institution license under Arizona law. And this care home, or not care home, but this facility does not require that license. They don't need a healthcare institution license. They're not going to ask for a healthcare or apply for a healthcare institution license. There's no healthcare institution license here involved whatsoever. The definition under Scottsdale ordinance for a care home requires being licensed as a care home institution under Arizona law. This place is not so licensed, and I don't understand where the zoning administrator gets his argument that it is a healthcare license, just because there's a different kind of license that they do need. And I guess under some interpretation, there's like some healthcare adjacent services being provided, I suppose. But it doesn't change the fact that there's a specific healthcare institution license under state law that this facility does not need. The state did create a specific license for these sober living homes, but they did not create it under healthcare institutions. It's not a healthcare institution. So even though it does require a license, it's not a healthcare institution license. It's a completely different section of the law and completely administratively handled differently and separate. So I have to say, and I will vote, that the zoning administrator was capricious and arbitrary and abused his discretion. And I got a randomized list here, so I'll go down. And Board Member Didi, you have comments as well?
Yeah, the first thing I just want to say is that it's important to remember what we're doing here and what we're not doing here. And what we're not doing here is making policy. What we're really doing is interpreting the ordinance language and considering any impact that the Fair Housing Act may have on that language. So I agree with Chair Kaufman. I think when I look at the definition of a care home, that the sober living home does not fall within that definition. I think it's very clear that the reference to a healthcare institution under Arizona law refers to something that does not include the sober living home. And I think it's very instructive that at the time these amendments to the ordinance were passed, There was no licensure of a sober living home under Arizona state law. So it seems to me that it could not have been possible for the city council to think that that was included within this reference to healthcare institution under Arizona law. So that criterion needs to be satisfied in order for a care home to exist, and I don't think it has been satisfied. The second criterion is that there are on-site supervisory care services, and my understanding from all of the evidence that's been submitted is that there are no supervisory care services being provided on site. So I also believe that the decision of the zoning administrator was in error. Thank you.
Thank you, Board Member Didi. Board Member Chacron?
Thank you, Chair. I agree with my fellow constituents here. And I appreciate everybody's coming up and speaking, especially the people that have gone through addiction and people that live in the neighborhood. But we're not here to make a decision for this facility to be in here. We're actually here to make a decision if it's a care home or not. And that's really what it comes down to. So all the public comment is great, but it really shouldn't impact what our decision is. We're looking at this as reading the rules and the laws and what the state and the city do. And unfortunately, it's backwards, in my opinion. There's nobody on the same page. And just the way that Board Member Didi explained is exactly the way that we're looking at this. I wish that everything was lined up. We wouldn't have as many lawyers as we have if everybody understood exactly what it meant. And so when I look at it as well, I don't believe that it was interpreted correctly. And I agree 100% that it needs to be relooked at based on what a care home is. And we have new laws coming into place. And I hope you keep pushing forward to make sure that the city of Scottsdale is in line with whatever the state says. And then everybody understands where we should and shouldn't have these facilities. And I understand that if it's in your neighborhood, it's probably not what you want, but it's what we need. And these people need someplace to go to, and it needs to be regulated. It needs to be monitored. Maybe it needs to be monitored more than what we do right now. But for us, I don't believe that we looked at it correctly the first time. And so I believe we need to look at it again. So I agree with my board. Thank you.
Thank you, Board Member Chacron. Board Member Gonzalez?
I would agree that the classification of a care home requiring a license was probably inaccurate. There was another license that this home will have to acquire to operate, the sober living license, but that's not, as near as I can tell, part of the city of Scottsdale's zoning requirements yet. I think the code needs to be updated to more reflect what's going currently. I do understand the concerns of the neighborhood, but I also understand that we need to help people when we can. The one thing that does bother me is that I was under the impression all along there was no supervisory help at this complex, but I understand now there's staff. When I read through some of the documents, I see that that under license of a sober home shall ensure that all provisions for the use of, or they call it the provision of naloxone. Is that the correct pronouncing?
Naloxone, it's a drug for overdosing on opioids.
It's some type of a medication that's available to residents. It's not self-administered, but the staff is instructed to notify the residents that it is there. So obviously there is medication self-administered, I would think, on site. And that was something that was not clear in our initial discussion. So I think somewhere there's holes on both sides on what sober home is required to do. And I'm not sure I was completely aware of all of that. But I think that the classification is probably incorrect since you don't need a health license. And I think that in that case, I'll have to agree with the rest of the board that it's not a care home. Thank you.
Thank you, Board Member Gonzalez. Vice Chair Metz.
Thank you, Chair Kaufman. I might be an outlier here. The standards are pretty high to find that a decision or an interpretation is arbitrary, capricious, or abuses the discretion. I think the zoning administrator approached this in a thoughtful way. He presented some reasonably cogent arguments to support his interpretation. I believe his interpretation was consistent with prior interpretations, so it wasn't arbitrary. And I also believe it's consistent with the intent of the council when the city council enacted the ordinance and established the text amendment to the city zoning ordinances. I'm not an attorney, but it still seems to come to what the definition of a care home is. And I believe there's a different definition at the state level than there is at the city level. And that's because the ordinances and the statutes were passed at different points in time. I believe the zoning administrator is an employee of the city and not an employee of the state. It's his job to interpret the city code. And when he does that, he should be looking at the intent of the council and the intent of the ordinance that was set up. So I respectfully disagree with my other board members. I don't believe that the zoning administrator's decision was arbitrary, capricious, or an abuse of discretion. I'm not sure. I don't think it's in error either from the perspective of what I believe Mr. Grant was tasked with doing. So I will not be voting that this was arbitrary, capricious, or an abuse of discretion. Thank you, Chair.
Thank you, Vice Chair Metz. Board Member Wagner.
I'll keep mine short. I found consensus. I found consensus with the rest of the board in finding that it was arbitrary, capricious, and an abuse of discretion. I do believe that it boils down to how we're defining care home and really focused on supervisory care as a defined term versus supervision in a non-care setting. And that is a confusing topic in our ordinance and the definition of a care home. But I do find it in error that it was deemed a care home. So I'll be voting in support that it be overturned.
All right, thank you, Board Member Wagner. So I think it sounds like we have a majority to overturn the zoning administrator's decision. And I don't know that we need, does anyone have any recommendation on what we should do other than simply stating that the error was that the facility was defined as a care home when it should not have been? Or does anyone want to go beyond that?
Chair Kaufman, I might defer to our attorney. I think I don't think we have to state a reason in the motion. I think we just have to have a motion that it was in error. Is that right?
Chair Kaufman, Vice Chair Metz, that's correct. You can simply find that the zoning interpretation was arbitrary and capricious or abuse of discretion. I'll note that those are alternatives, not necessarily and in the conjunctive, they're disjunctive. You could, if you felt there was you could say what the board feels that the appropriate interpretation is, but it's not incumbent on to you. The issue before you is to either uphold the zoning interpretation or find that it was not, should not be upheld.
Okay, then with that, unless anyone has other comments, I'm going to make a motion that we overturn the zoning administrator's decision as being arbitrary, capricious, or an abuse of discretion in defining the Scottsdale Recovery Facility as a care home, and that it is not a care home, either because it's not licensed as a healthcare institution under state law, or because there's no supervisory care being provided. Do I have a second for that motion?
I second that motion.
And then I guess we'll take the roll call vote.
Chair Kaufman,
Aye.
Vice Chair Matts,
Nay.
Board Member Gonzalez,
Aye.
Board Member Chacron,
Aye.
Board Member Wagner,
Aye.
Board Member Didi.
Aye.
Thank you.
Thank you. And I think with that, that finishes off 6BA 2021, and we did provide the requested reversal of the zoning administrator. Is that going to satisfy you guys, or do we need to move on to the?
The one difficulty I have is, and Michelle answered this, is as part of our application to the state, we have to give a zoning attestation of what we are. And so now that you have decided that we are not a care home, which we very much appreciate, if you, I don't know if it's appropriate under the reasonable accommodation, but we do need some direction, at least that we're allowed in the R3 zoning district. And so if that is a reasonable accommodation, then I think we would like that decision so we can go back to the state and submit our application. But if not, then we will take the.
I mean, were you told that you're not allowed to operate in R3 for any other reason than you're a care home?
No, that was the only reason, Chairman.
And in your accommodation request, was there anything you're asking for other than to be able to operate, notwithstanding that you're defined as a care home?
Yeah, so under the reasonable accommodation application that we submitted, we asked to be deemed a family and to be allowed in the R3 zoning district.
All right, then I think maybe everyone would appreciate a little time to figure out what's going on here and maybe to get out of here tonight. Can we continue this or table it for the time being? Is that part of parliamentary procedure? Maybe Brian Clough or Eric, you can answer. So then we can figure out whether we need to proceed with this one or not.
Chair, the request is for the 8BA 2021 is the request by the owner for reasonable accommodation based on disability to the City of Scottsdale Zoning Ordinance to allow a proposed sober living parenthetical care home use of the property. So if the board could vote to continue it, if you want, you could address that and address the accommodation as requested to just clarify the intent of the board. So I think you can entertain a motion either way. I recommend that if you do continue, you continue to a date certain rather than.
Well, why don't we continue, because we've already got planned a January meeting. We've continued another item to January.
Chairman, if I may, I'm so sorry. I don't mean to interrupt. Michelle just reminded me that the state has given us a deadline of December 8th to submit our application, or December 2nd, I apologize, December 2nd to provide that zoning attestation.
And you need us because you don't think the city is going to tell you that you can operate even though you're not a care home?
I'm not sure. That's what I'm trying to clarify on the record. I think the granting of our interpretation appeal should allow us to provide that zoning attestation and have support of the city. By not taking the next step of defining what we are, whether that's a group home or a family, both of those uses are allowed in R3.
Can I ask the
Because
board?
you took these as separate issues also for the purpose of the record, having no decision on that separate issue would just leave it open.
Chair, if I may, perhaps the staff is here and the zoning administrator, I believe, is here and their legal counsel. Perhaps the board could take a 5-minute break and discuss with the applicant and see if we can't get an understanding and present the board with a stipulation regarding the reasonable accommodation.
Sure, go ahead and do that while I try and review it as well up here. Thank you. We'll take a
Just for clarity, 5-minute break.
5-minute recess.
Okay, thank you.
Are we ready? Is someone gonna come present at the podium?
Chair, you just need to call the meeting back to order, so.
Order.
Chairman Kaufman, members of the board, the city's willing to attest that this is a single family use as an accommodation, reasonable accommodation. And so hopefully that defines for them what they are relative to the zoning ordinance.
Okay, then can you go ahead and do that?
Chair, what I recommend, I think what they'd like is the applicant, if the applicant agrees with that, then the board would enter a motion accepting the stipulation that the reasonable accommodation be granted for this property to be treated as a single family usage. Is that
I mean,
correct?
why do they need this? Isn't it a single family usage?
Well, I think that's the clarification that the board didn't make. You overturned the decision and the zoning administrator interpretation. You didn't go further and clarify what the use. So the city is willing, and so I recommend you accept the stipulation since the parties are in agreement that this accommodation can be granted. It's just a matter of the board accepting that stipulation. That would also dispose of the second case, 8BA 2021, and presumably that should conclude the meetings.
Okay, so the application for the accommodation, it was requested an accommodation allowing 2 to 4 disabled sober adults to live as a family in each dwelling unit on the property. Is that what you're asking us to?
I think that's accurate unless I see objection from, I think that's so. If that chair would entertain a motion to that, accept that stipulation and adopt it as the board's decision, that I think that will be sufficient.
Okay, well, let's just do a motion. If you guys don't agree, then don't vote on it, but.
Chair Kaufman, but I just want to be clear. We're assuming, I'd like Ms. Dukes to accept that as a solution that she's satisfied with before we go through the effort of making the motion. I assume this is negotiated between the two parties, but I want to make sure that if we take this action to accept the stipulation that this be treated as single family home as a reasonable accommodation, that will meet your needs.
Yes, so long as the motion includes that we, as the reasonable accommodation, we are allowed in the R3 zoning district. This particular use as a family.
Okay, so what you requested on your accommodation is an accommodation allowing 2 to 4 disabled sober adults to live as a family in each dwelling unit on the property. And I think that satisfies you because on the property means that property in R3. Do you have any other issues with that language?
No, yes, we agree with the language that you just stated into the record.
Okay, then this is now for 8BA 2021, the reasonable accommodation request, and we're going to skip all the presentations. I'm going to make a motion and we can discuss as you guys want to and then vote on the motion. And the motion is to provide a reasonable accommodation allowing 2 to 4 disabled sober adults to live as a family in each dwelling unit on the property. Do I have a second for that motion?
Second.
Does anyone want to have discussion on this? Yeah, go ahead, Board Member Gonzalez.
When I read the text on 8BA 2021, it talks about a proposed sober living care, parenthesis, care home. So this motion is not the same thing as we're being presented.
Yeah,
We
so
need to
just
withdraw.
if I could clarify, if you look at, I'm looking at the staff report beginning on page 4 of 10. At the very end of that, it says request analysis. And they've got 2 separate requests here. In the first request, they're only requesting what I read. In their second request is when they're asking to be allowed to operate as a care home. So we're not dealing with the second request. The motion doesn't relate to the second request. It's only their first request in those two.
Okay, but they've made two requests. Do we accept one and reject the other to finalize?
No, I think we only really need one motion, in my personal opinion. We'll give them the request one and we'll ignore request two.
Chair, if I may, just to respond to Board Member Gonzalez, that's within the scope of the board has discretion to find the reasonable accommodation that's appropriate. So that's within the discretion. I don't think you're bound by the exact nature of the request, so, as stated in the staff report. So
Thank you.
Any other comments on this? All right, so the motion is to provide a reasonable accommodation allowing 2 to 4 disabled sober adults to live as a family in each dwelling unit on the subject property in 8 BA 2021. And we have a second from Vice Chair Metz. And can we have the roll call vote, please?
Chair Kaufman,
Aye.
Vice Chair Metz,
Aye.
Board Member Gonzalez,
Aye.
Board Member Chacron,
Aye.
Board Member Wagner,
Aye.
Board Member Didi.
Aye.
Thank you.
All right. And I think with that, we'll adjourn the meeting.